that a urgent motion may be placed before
Please mention on Wednesday. Mentioning is only on Wednesday. It is indicated in the list. Yes.
For mentioning a matter where Mr. Shaunak Bhattacharya Millard was for the petitioner.
Yes,
Millard, he was appearing for the petitioner.
it is to be released.
It's up to your lordship, Millard.
Uh,
Millard, may I supply the number, Millard, by last.
Supply the number. It will appear under the heading to be mentioned.
May I be kindly permitted to mention this matter? This matter was returnable today, my lord. It
Please.
is not appearing in the list.
It is
not
not returnable today.
Yes, my lord. 10th March. May I submit the copy of the order, my lord?
No.
For release, my lord. So, not what
Please mention on Wednesday.
Last page আছে আমারটা লাস্টের পেজে লেখা আছে তাহলে on the next page of the order.
Please mention on Wednesday.
I shall come back.
My lords, there's some urgency. I understand. I am extremely apologetic. The thing is, the matter was returnable on 28th of January. My visitation rights have been denied, not seen my daughter for 1.5 years. But the issue is the judgment is set to be delivered this Thursday. Now, there's no stay. So what happens if the Section 9 proceedings is adjudicated upon? This revision will be infructuous.
Why did not mention last Wednesday?
Well, I mentioned. I have also given the slip.
Then check up what is the endorsement made in the mentioning slip. Yes, call the list.
My lord, my matter has been listed as item 50 upon mentioning. The
50.
50. The returnable date before the trial judge is on 12th. That's day after tomorrow.
This cannot be updated further. Yes, call the list.
My lord, I'm preparing for the petitioner. And
Now for the respondent.
as per your lordship direction, petitioner and the opposite party sit together. But
Yes.
they are not agreeable. The petitioner is not agreeable. The
Demand amount, my lord, the parties could not reconcile, my lord. Initially, there was no demand, but lastly, the wife has asked for 30 lakhs, including jewelry and all.
and the
So the main matter is to be heard.
Yes,
my lord.
My lord, let there be direction for
So
affidavit,
it
my
was.
lord.
What is this matter?
My lord, section 24 from Beharampur to Howrah
Transfer.
transfer.
But my lord, Howrah court does not have jurisdiction. It's the Amta court, my lord.
My lord, nowadays the wife is residing and not being able to reside at his home. He is residing just as uncle's home as she is going
You
on
want to
from
file affidavit?
Yes, my lord.
my lord.
Passover. Yes, next.
My lord, I am on behalf of the petitioner. This is the application under 227 of Constitution of India for expeditious disposal of title appeal, my lord. before, it is pending before second FTC ADJ Barrackpur.
What is the stage of the suit?
No, suit already,
Appeal.
appeal. Because I have got the decree, suit was instituted on 2000.
So you want expeditious disposal of the appeal?
Appeal, my lord.
Appeal,
It is pending before.
7th of April, it has been fixed.
No, my lord.
Yes. 18th of December 2023, come to the order 18th of December 2023.
Yes, ma'am. But
It has been fixed on 17th of April.
April. But my lord, my predicament is that
What is the next date fixed?
second ADJ is retired. Bench is vacant. And there is, but this charge code is first ADJ, FTC.
Charge court cannot hear an appeal.
My lord, because the suit is, I have got the degree on 2017. Thereafter,
Charge court cannot hear the appeal.
that is, but my lord, this bench is vacant. So my lord,
If you want this to be transferred, then you can apply before the Lahore district judge. I will give you that liberty. If you want it is to be transferred to any other court, since the court is vacant, I will give you liberty to, because directions for expeditious hearing when the court is lying vacant cannot be passed. What is the next date fixed?
next date fixed, my lord, I got the, this is 4th August 2025.
4th August.
4th August. Because I am a senior citizen, my lord. A lady teacher, retired lady teachers. And suit has been instituted in
This
2000.
application under Article
I
Yes.
I am for the petitioner. My lord.
Yes.
I am for the petitioner.
Please use the microphone.
The opposite party plaintiff filed a suit before the learned senior judge at Jhargram, civil judge Jhargram. With a prayer to restore the possession of the premises, evicting the tenant with other relief. Defendant, petitioner, the defendant filed writ petition along with counterclaim, praying to restore the tenant, to restore the possession to the tenant. এক নম্বর 2 নম্বর হচ্ছে cost rupees 5,000 from the date of the disposition. তিন নম্বর হচ্ছে
Yes, what is the impugned order? What do you want?
impugned order হচ্ছে learned civil judge senior division ordered the defendant to pay ad valorem court fees.
Yes, that you have to pay. Counterclaim is just like a suit.
Ad valorem court fees without শেষদার রিপোর্ট তো রিপোর্ট মানে আনটিল না
Why? You know the valuation, you know the court fees, you have to pay that. Uh,
Mr. Minalkanti Ghosh appearing on behalf of the petitioner, item number 6. Mr. Minalkanti Ghosh, my lord, appearing on behalf of the petitioner.
yes,
Mr. Ghosh has to come, my lord, court today for his personal difficulty. I am praying for not today.
what is your prayer?
I do not know, my lord.
This application under Article 227 of the
But I'm for the petitioner defendant.
Yes.
Suit for declaration and for injunction filed by a trustee. In the said suit, the main trustee died. An application for
Suit filed by the trustee.
Yes, suit
Where
filed
is
by
the plaint, Mr. Day?
My lord, plaint. Plaint I have not annexed. If your lordship kindly takes over the plaint, I will.
Yes.
Trustee.
Yes, what happened thereafter?
Or in the said suit, my lord, the trustee died. An application was for substitution was filed by one of the beneficiaries. We objected to it. Our points were that a beneficiary cannot.
He was the sole trustee.
He was the sole trustee.
As per the trust deed, what is the method of appointment of trustee or?
It should be through the court. It should be through the making an application before the learned court. That was not done so. Now, lordship, what has happened is now he is trying to become a trustee by a indirect method which has not been prescribed. Section 73 and section 74 is very specific regarding the Trust Act as to how a trustee is to be appointed. Moreover, my lord, an application for substitution was filed. We objected to it. The learned court below, without determining whether he is a legal representative and whether he can be substituted or not, though a duty was cast under Order 20 Rule 5, the learned trial court overlooked such objections and passed an order, impugned order, thereby allowing the said application for substitution, lordship. That
Who has been substituted?
One of the beneficiary, who is right now the opposite party number 1.
Show me the provisions in the trust deed with regard to appointment of the trust. Did you take that point in the written objection? Show me that.
In the written objection, lordship, your lordship kindly comes to page 17.
Yes, show me that part with regard to this appointment of trustee.
If your lordship kindly comes to page 17, প্রকাশ থাকে যে কোনো ব্যক্তিকে ট্রাস্টি হিসেবে বা ট্রাস্টের পক্ষে পক্ষভূত করিতে গেলে ট্রাস্ট বোর্ডের বিধান অনুযায়ী তাহাকে ট্রাস্ট বোর্ডের সিদ্ধান্ত অনুসারে কোঅপ্ট করিতে হইবে।
Trust board, there is no board according to you. So who will?
My lord, I should be very candid before lordship. I do not have the trust deed right now. If your lordship directs me to show to your lordship the trust deed, I shall show to your lordship on the next day or any other day as your lordship so directs. But in the meantime, my lord, the application has been allowed and the learned court bill is going to proceed with the matter further. If your lordship kindly sees Order 22 Rule 5(1),
Order 22 Rule 5 is there. It has to be decided.
Determined. It has to
There
be
is an
determined.
objection.
There is no.
But your
determination
objection
at
is
all.
also very vague,
But there is no
not
determination
very
at all.
specific.
Lordship, there is no determination at all.
You have not raised any specific objection. What will be decided, Mr. Day?
If your lordship kindly comes to para 5 and 6 of page 17 once, I have stated so, my lord. প্রকাশ থাকে যে
But you have not said who are the trustees, who are the existing members of
Already-
the trust board.
Yes.
Nothing has been said.
It should have been more in details, but lordship, that is a lacuna, of course.
So
But lordship kindly also
you are
appreciate.
finding fault with the learned judge.
No, I'm not finding fault, lordship. This is my humble submission.
This was not decided. You have not taken that point in the objection
But
either.
still, my lord, the learned court will ought to have decided Order 20 Rule 5, the standards.
If there is an objection, specific objection in that regard,
Yes, I have taken that point, but very faintly. If your lordship
So-
kindly comes to para 6,
decided also faintly.
very. Lordship, if your lordship kindly comes to para 6.
Objection was faint. Decision is also faint.
Or I can be wrong, but the court cannot be wrong, lordship.
No, Mr. Day, the question is unless you take a specific objection in that regard.
No doubt,
The
lordship, but
question is Order 22 Rule 5 if you come,
yes. Where
where a question arises as to whether.
the person is or not, or
Yes.
is not the legal representative of a deceased plaintiff or a deceased defendant.
So
That
you have not raised a specific question in that regard.
If your lordship kindly sees para 6 once,
Yes.
উক্ত দরখাস্তে উল্লেখিত শ্যামানন্দ সাহানা সত্য কিঙ্কর সাহানা ট্রাস্টির কোঅপ্ট ট্রাস্ট হিসেবে নির্বাচিত হয়েছিলেন।
Page
All-
17.
Page 17, para 6.
Yes. There is no dispute with regard to that.
ট্রাস্ট বোর্ডের একজন সদস্য ছিলেন, তাহার স্ট্যাটাস কখনোই বেনিফিশিয়ারি হিসেবে ছিল না। ফলত তাহার স্থলে ট্রাস্ট বোর্ডের কোনো মেম্বার ব্যক্তিকে মৃত ট্রাস্টির স্থলে সাবস্টিটিউটেড হইতে পারে না। So my point is that a beneficiary cannot be substituted as a trustee.
Who is the beneficiary?
Yes, one who has been sought to be Substitute is the beneficiary. He's not a trustee.
Show me the provisions in the trust deed. If there is a provision that after this date, trust will come to an end, then
Kindly allows me some time in, if I
Mr.
can
Dale
serve
on
come
it.
back, I shall come with the trust deed
Dale
also.
Honored Advocate appearing for the petitioner. Yes, next.
Lord, all parties
Or
have,
9 is also similar. 9 is also.
9, same.
Lord, all parties are present, my lord, with regard to.
Mr. Banerjee, let me go through the motions first. Yes, next.
It's not 8, my lord.
Yes.
The suit for eviction and for recovery of possession filed by the plaintiff, my lord, I'm the plaintiff, and also for declaration. In the same suit, my lord, at the belated stage, an application for amendment has been filed by.
You started with submission belated stage. What is the belated stage?
The candidate, it is
What is the belated stage?
at the argument stage, no doubt about it, because it is recorded over there, and I cannot
So
influence.
no
that.
explanation with
Yes,
regard to
explanation has been given, lordship,
advice of the senior advocate.
advice of the senior advocate. Later on, because it was not.
What
given at
what
that
is the
point of
proposed amendment, Mr.
proposed
Dale?
amendment is only certain elucidation of facts regarding the title deeds. Because I will
That-
already challenge the title deeds and I've prayed.
You have challenged its Ashun.
May I serve and come back, Lordship? Kindly allows me to serve.
Sir will come back with a direction that should not be stayed, arguments will be over.
That the arguments is Lordship, kindly appreciate, Lordship.
Since you have taken that point in the suit, no need to elaborate. You have, if the fact is there, so elaboration will be by way of an evidence.
My humble submission regarding.
Mr. Day, you need not plead evidence in the suit. If the basic foundation is there, nothing more.
Lordship, in my humble submission are these.
Others, evidence.
These amendments are required to be, my lord, added in the plain.
Show me the nature of the amendment.
If your Lordship kindly comes to page 15 and 16.
15 and 16, yes. Show me the,
Yes, the schedule is at page 6.
this is plaint.
This is the amendment of plain.
Where is the plaint?
Lordship, may I-
What do you want to incorporate?
Lordship, I want to incorporate the knowledge on which date I have come to know about the details of the said deed.
When did you come to know of the?
Or subsequently.
What is the date?
My lord, I have come to know on 22/9/2014.
2014.
Yes, when a report in respect of a
All right.
144 proceeding was filed.
When a report,
When a report in respect of a 144 proceeding was filed. So
show me your schedule of amendment.
yes, Lordship kindly comes to page 16. It's nothing but elucidation. বিবাদীগণ বাদীগণের সত্য দাখিল নালিশি সম্পত্তিকে তাহাদের দখলে বাধা বিঘ্নের সৃষ্টি করিলে বাদীগণ প্রথম পক্ষ হিসেবে ও বিবাদীগণকে দ্বিতীয় পক্ষ হিসেবে ইমপ্লিট করিয়া মাননীয় বিষ্ণুপুর এসডিএম আদালতে 22
Mr. Day, kindly come to the next page nearing the middle.
Yes, ma'am.
আরো প্রকাশ থাকে যে, place that loudly. উক্তরূপ দলিল বাদীগণকে ভয় দেখাইয়া ও তাহাদের উপর জোর খাটাইয়া নালিশি সম্পত্তি গ্রাস করার উদ্দেশ্যে উক্তরূপে, so execution is of 2001. This application under Article 227 of the Constitution
My lord, my lord, my lord, I am mentioning this matter behalf of the learned senior advocate Manju Agarwal. The matter is CO number 102 of 2025.
This is 791. This is not that matter. Yes, Mr. Mukherjee.
Granted apology.
Plaintiff is the petitioner before your lordship. By virtue of the order impugned, the application for amendment in respect to the injunction application is being turned down. May I just show before your lordship what is my original plaint? Page 10 of your lordship's brief, if your lordship takes up the
Amendment of plaint, we have not sought for.
plaint of
That has been rejected.
that has been rejected pending. But in isolation on the day of filing, both this amendment application filed together on the same day. Amendment of plaint as well as amendment of application for injunction. On the same day, keeping alive the application for amendment of plaint, this was taken up and rejected in isolation. But may I just show before your lordship what is my case? Page 10 is the original plaint. If your lordship,
Mr. Mukherjee, if this is rejected, that will go.
it's the same tune. In the same tune, it has to be.
So you are taking that risk.
But otherwise, this will be again my amendment of plaint will also go.
That is why. What is the reasoning for
Yes, kindly.
rejecting?
153, section 153, I have applied for. Read with order 6, rule 17. The court said
153.
general power of amendment. 153.
153 read with
Order 6, rule 17, read with 153. The court said the court do not have any power. Since your lordship knows it's a not pleadings definition is plain and written straight. That's why 153 is being resorted. Read with.
there is no other provision in the code which could have been resorted to except 153.
Application, not
Yes.
if your lordship takes up the original plaint once. It has been couched in a manner of declaration.
Where is your prayer for? Where is your schedule of amendment?
Schedule of amendment. The schedule of amendment in respect of the application for injunctions, it starts with page 57 of my lord's brief.
57.
Yes. Since in the application for injunction, the prayers are being quoted. Now the prayers is altered by virtue of the amendments sought for in the plaint. So this quotation is being only tried to be changed in the body of the application for injunction. Prayers are quoted. Injunction application is at page.
What do you want? What is the
That's why
scope of the amendment?
if your lordship takes up page 10, the plaint starts.
Yes.
I am the developer.
Yes.
I entered into an agreement with the original owner who died during pendency of this construction period, where the original development agreement and power of attorney was there. I constructed the house. After the death, the legal heirs are not willing to execute the power of attorney, so that I can sell out within the developer's allocated area. So by virtue of this, the plaint is being couched in a manner of declaration and injunction. But essentially, we kindly takes up page 21 once. Essentially, the prayer for specific performance is there. Prayer A kindly looks at the prayer. But this,
what is the valuation of the suit?
Yes, that's why, my lord, the valuation is now being changed by virtue of the amendment. The valuation statement and the prayer, which was couched in a declaration manner, now the specific performance of contract is being sought for. But the prayer was
Where
there.
is your application for amendment of plaint?
Plaint, yes, my lord. Plaint, my lord, if you are not page 43, it starts. Kindly takes up the schedule at page 46. 43 it starts, but the schedule starts at page 46. These factors are there. Kindly takes up page 49J, point number J. And tallies it, my lord, to the original plaint prayer. It's not that, my lord, I tried to be altered the nature and character of the suit even. And it's a pre-trial stage. Interlocutory application is still pending.
So I've applied at the right time, not prior to, they are filing the order 7 rule 11.
Yes, that's.
Lordship, I am applying for the petition. Well, in this revisional application,
আচ্ছা মিস্টার মুখার্জি প্লিজ আসুন তো একটা ওইটাকে যেটা করলাম তো ইট ইজ মেড ক্লিয়ার না তার আগে একটুখানি এটা লিখুন there shall be an order of stay of hearing of the application for injunction till the end of May 2025 or until further orders. তারপরে লিখবেন it is however made clear. তাহলে ওখানে না excluding injunction applicationটা লেখা
is the impugned order after page 49 passed by the learned
So
civil
Mukherjee, you are opposing.
passed by the learned civil judge junior division first court at Barasat, rejecting the prayer for police help to implement the impugned order granted in the suit.
Where is the impugned order?
After page 49, Lordship.
After page
49.
No. Ad interim order. Ad interim order which you are seeking to
Lordship,
implement
page
police help. Where is that?
27.
33.
Page 20.
Page 33.
33.
To 24, Lordship.
Yes. What happened to this ad interim order?
Pending.
Pending.
Pending. And construction is going on.
No injunction against construction.
But not to disturb, restraining not to disturb the possession. So the construction is not the disturbance.
Kindly see page 44 is the application. I'm sorry.
Yes.
I am the owner of the land measuring out 2.468 decimals out of 13 decimal. Encroaching the total
possession.
Lord, no, my lord. When the suit was filed and the injunction application has moved, specifically I have stated at the paragraph, the defendants made ready to construct. Then I move before the civil court. The civil court, after hearing the interim order, was granted. But in force of the interim order,
When you filed the suit, you were in possession.
When
you filed the suit, I'm asking you, when you filed the suit, you were in possession.
Yes, Lordship.
Show me the finding from in the ad interim order of injunction that you were in possession. Show me from
Lordship, kindly see the local inspection report.
Please show me from the order of ad interim injunction that the court held that you are in possession. Show me that. Show me from page 33.
Page 33, once again, your Lordship, kindly.
Yes. Show me where it has been held that you are in possession.
that the primary purpose of getting interim order is the preservation of property in dispute till legal right and conflicting claims of the petitioner parties before the court as adjudicated, and at the same time to evolve workable formula to the extent called for by the demands of the situation, keeping in mind
No, show me that,
pros and
that
cons.
line that the court held that you are in possession. Show me that.
But your lordship kindly consider my statement, that
No
paragraph.
statement will not do.
But the-
You may make many statements,
My lord,
but the court has not found favor with those statements.
my lord, when I move before the learned civil court,
That
the
is the
land was vacant.
difficulty. That is the difficulty in implementing an order of an interim order of injunction. I am directing the what is the stage of the injunction application. It's otherwise
is-
ready. I am directing the injunction application.
Written
to be-
objection they have filed.
So what is the date fixed for hearing of the injunction
Next
application?
date, lordship.
I am directing the injunction
11th March.
11th March, 13th March was the date fixed.
13th March.
13th March, my lord.
13/3/25 for hearing of.
Or it has been preponed to 11th.
No, my lord. 13th March is the date fixed for hearing. Now, my lord, my instruction is that, my lord, 13th March.
The 13 is the holiday due to
13th March, my day after.
Holi.
13th is holiday.
14th Holi, sir.
14th only, sorry. huh.
13th March, kindly direct, my lord. My only thing, kindly see, my impugn order, court is of the opinion, I don't kindly see the impugn order. I am of the view that whether he is in position or not.
The
My
special,
last line, considering the fact and
How that can be decided in an application under section 150 on this.
that court is saying.
So I am setting aside this order. I am allowing that.
Court is of the opinion that he is asking for, my lord, police cell, but, my lord, court is confused as whether he is in position or not, because in the application.
But there is an order directing, restraining you from disturbing the possession.
Without finding.
disturbing also, the construction is also disturbance. Solely. Because when the suit was filed, no construction was there. The
Let the injunction
defendant was
application-
ready to construct.
So now construction has been made. Up
Lordship,
to what extent?
Complete.
not complete. The
All right.
report of the special officer.
What is the extent of the construction? 1 story, 2 story, 3 story,
G+3.
G+3.
Lordship,
So superstructure is already complete.
No. Incomplete building.
Superstructure I am saying,
Structure is.
complete. So wait for 2-3 days. I am directing the injunction application to be disposed of. Thereafter you
Lordship,
take step.
Lord.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order being number 16 dated 20 service taken on record. Yes, next.
12, my lord, I am for the petitioner, my lord. The mother of the petitioner, my lord, suffered a decree for eviction. The sons are not party in that suit, my lord. No 6-4 notice was served upon the sons. Now, in the execution proceeding, the sons filed, my lord, one application that since we are not in the party of the eviction suit, no 6-4 notice was served upon us. The original tenant was the grant.
What is the application filed?
Section 47 read with order 21, rule 100 and 101.
Order 21, rule 101.
100 and 101, read with
Yes.
section 47.
So this is an appellable order. Order 21, rule 101 is a deemed decree according to order 21, rule 103.
But below 47 is also there. By amendment was not
47, your right title and interest cannot be decided. So you can restrict your submission with regard to execution, discharge and satisfaction. If you say so, I will entertain this civil division application. But no issues with regard to your independent title, which you can raise by way of order 21, rule 101.
But
It's
in
your choice.
in section 47, my lord, the
Section 47 is an objection with regard to execution, discharge and satisfaction.
yes,
So you are only on that.
and there are no
And
kindly allow me. And the code says, my lord, no separate suit should be filed. It shall be
where
determined.
is that bar? That is, no separate suit should be filed. Where is that bar? Under what provision? Section 47.
Section 47. your lord.
Yes. Order 21, there is no separate bar. Where is your prayer?
Yes.
Show me the application.
Kindly come to, my lord, page 41. It is the application, my lord, and the yes, it was primarily filed under section 47, but later it was amended.
Amended to order 21, rule 101.
100.
Then
But my lord, my only issue is that the learned court below never decided the objection on the basis of the merit, my lord. Learned court below relied upon some order passed in a title suit and title appeal, where we were not the parties.
order 21, rule 101, it's an appellable order as like a decree. 103. Order 21, rule 103, I think. Yes, orders to be treated as decrees. Shall have the same
But-
force and be subject to the same conditions as to an appeal, or otherwise as if it were a decree.
But in the impugned order, learned court below held that instant miscase is not maintainable as per provisions
So
of
it
the
has been decided one way or the other.
not maintainable under order 21, rule 100 and 101. Then I cannot go for the
You are accepting that. If you accept that, end of the matter.
then, my lord, I shall file.
After some argument, the learned advocate appearing for in accordance with law. In accordance with law. 13 years. Ram Prakash Banerjee. None appears for the petitioner at the time of. Yes, next.
14,
my lord, I appear on behalf of the petitioner, my lord. Lord, is an application for expeditious hearing of, my lord, the miscase filed by the wife, my lord.
What is the miscase for?
Miscase is, my lord, for alimony pendente lite, my lord. Affidavits have been exchanged. my lord.
Miscase for alimony pendente lite.
Yes, my lord.
You are
Affidavit.
for the wife.
No, my lord, I am for the husband.
Do you want that miscase to be disposed
Yes,
of
my lord.
early?
Yes, my lord. Affidavits has been exchanged on 18th of February.
What is the next date fixed?
20th of May.
If affidavit of assets filed,
Yes, my lord. Exchanged. 18th of February, it has been exchanged, my lord.
so 20th of May.
May, my lord, is next date fixed for hearing of the miscase and for filing additional written statement in the matrimonial suit.
So let the first miscase be decided. This application.
fifteen,
20 is the petitioner in a suit for partition by the impugned order application for amendment has been rejected. When, my lord, I prayed for declaration that the deeds of gift, my lord, which has been disclosed in filing written statement, are, my lord, void.
You are not aware of those deeds?
No, on the, my lord, after the disclosing the written statement, I have come to know, and within, my lord, time I have filed that.
But
But the
Mr.
trial court
Mahato,
has says,
there is a decision which says registered instrument amounts to a public notice, limitation will start from the date
But
of
not a limit-
registration. So,
the limitation for
so
filing
it's a
the suit is 3 years from the date of knowledge. My lord, therefore, from the
date of knowledge, registered instrument, registration is itself a public notice. So limitation will, there is a Supreme Court judgment that is against you.
But here, my lord, that is not the point, my lord. In amendment application,
Yes, amendment, you, can you
court
challenge
has
the
said-
deed after the time has expired?
my lord, court
Time barred amendment cannot be
Yes,
allowed
it is-
express its time barred.
Yes, but it is question of fact and law, my lord. It is required to be adjudicated. It is not that from the date
Time
of
barred,
registration.
Mr. Mahato.
No, not from the date of registration, from the date of knowledge. Well, knowledge of
Public
registration.
notice from the date when it was registered in the book volume. I think that is the decision of the Honorable Supreme
That
Court.
will be decided, my lord, at the time of hearing of the law. But my lord, court has said that it will change the nature of character of the suit, therefore it is not permissible. The finding, my lord, kindly see in the important.
That I can substitute with different reason. May not be partition suit, so declaration is implicit in that suit photo. That I can take care of that. Reasoning can be substituted. So, but what is the effect?
Yeah. It is almost.
But rejected in total.
Yes.
No.
Amendment application has been rejected on the ground that the nature and character of the suit will be changed. On perusal of the petition and hearing the administration says, I find that this is a suit for partition. However, new prayers which the plaintiff proposed to insert relates to declaration of two deeds as illegal, void, and without
Where
jurisdiction.
is your amendment application?
Yes.
At what stage, Mr. Mahato? At what stage you have?
Injunction application is fixed for hearing.
Injunction application is fixed for hearing. Trial has not started. No, has not started.
Your lordship had the occasion to appear on behalf of the petitioner in a separate proceedings.
Since I'm not inclined to take up this matter on personal ground, this
I'm appearing for the petitioner. My pre-trial amendment, order 6, rule 17 application that has been rejected. Against that order, the divisional application which I have filed, lordship. Shoot for eviction against a tenant. Lordship, I have filed 17172 application. In the 72 application, I have raised dispute with regard to landlord-tenant relationship, and I have also stated in the written statement, lordship, few facts needs to be incorporated by way of amendment. I have filed one order 6, rule 17 application.
show me the schedule of the plaintiff.
Schedule
No,
of the
written
plaintiff.
statement, sorry. Show me the show me the original written statement first.
Lordship, page number 17. Start with page number 17.
Yes, so by way of amendment, you are trying to challenge the landlord-tenant relationship?
No. It has already been challenged. Few facts needs to be incorporated. Who is the only original owner and who is the original landlord of the suit premises, which I needs to be incorporated by way of amendment. And
original owner
as well as landlord, lordship. That's why I have filed 1617 application, which has been rejected. Lordship, kindly come to the impugned order, lordship, only.
Show me the written statement first, that portion. Show me the amendment. Thereafter, I will come to the impugned order.
Lordship, kindly come to page number 18, paragraph number 6.
Yes.
And relevant portion, page number 19. Lordship, page number 19, lordship. For adjudication of relationship, the defendant filed an application under section 70 of West Bengal Premises Tenancy Act, which is pending. At that time of the 70 application was pending. In the 70 application, which has been disposed of, lordship, kindly come to order of the 70 passed by the learned court below. Lordship,
yes.
That is page number 33, lordship. relevant portion, page number 33. That's it, middle portion, first, second, third, fourth paragraph. Learned advocates for both the parties submitted that the defendant has disputed the relations of landlord and tenant in petition under section 72 of West Bengal Premises Tenancy Act, and the said issue be kept open for adjudication at the time of trial after framing specific issues on that point. At this stage, the petition under section 72 WBPT Act may be disposed of on contest. Lordship, it was the submission, and Lordship, very next page, page number 34, Lordship, kindly come. The issue not yet been disposed of.
Which issue?
That landlord-tenant relationship. Lordship, that the petition, may I read, Lordship?
Yes.
The petition under section 72 of West Bengal Premises Tenancy Act filed by the defendant on such and such is disposed of on contest but without cost. It has been held that
Disposed of on consent.
on consent. On consent, that issue needs to be, that issue is.
Show me the application for amendment, schedule of amendment.
Lordship. Kindly come, running page 37, Lordship.
Yes.
Running page 37, schedule above referred to, that is 6A to up to, Lordship, 6E, which needs to be incorporated. Few facts. And apart from that, there is a title suit pending, that is 1624 of 2021.
What is that suit for?
Suit in between the parties to the landlord and in between the parties of landlords. I mean the co-owners. That is
For partition.
not partisan. They have fought for that. They are not the owner actually. Whatever, that will be decided at the time of trial. I needs to be incorporated those facts. Nothing else, Lordship.
Who was collecting, whom have you paid rent? Prior to the institution of the suit?
Prior to the institution, Lordship, it was under Tomalini Devi. Prior to institution.
Kindly
I have
come
not,
up to page 18, paragraph 6. You turned over to page 19, but place page 18.
Lordship.
Nearing the middle.
Lordship, the defendant states that he had all along known one Tomalini Devi and Srimati Pranita Bhattacharya as the owner of the premises and originally Baidyanath Sahu receiving the rent from the tenant. And after his death, sometime two wives of late Baidyanath Sahu collected rent from the defendant. Sometimes thereafter, Binod Kumar Sahu himself, shown as the executor in the estate of Baidyanath Sahu, such and such address, collected rent from issuing rent receipt there against, and on his refusal from the February 2018, the defendant started depositing rent with the office of the rent controller Calcutta to the credit of the Binod Kumar Sahu, the plaintiff herein which briefly described.
You have also deposited in favor of Binod Kumar Sahu.
Lordship, I am admitting whatever, Lordship, only one thing. There is this provision under section 116 of the Evidence Act I cannot challenge. That is admitted fact. But he is not my inducting landlord. So far that is concerned, whether he has any right title interest over the suit premises, that has to be seen.
Is it necessary in a suit for eviction under section 6?
Suit for eviction, there is a bar under section 100.
Ownership necessary?
Ownership not necessary. Ownership not necessary.
So landlord?
He is not at all the owner and the landlord, Lordship.
How do you say so? You have admitted that he was collecting.
He was collecting.
What is the definition of landlord, sir? Please come to the definition of landlord.
I don't have book.
Yes, a boy here. Section 2.
3, Lordship.
Yes.
Landlord includes any person who for the time being is receiving or is entitled to receive the rent for any premises.
So he falls within the description of.
Within the description, Lordship, only one thing, Lordship, kindly consider, he is not my inducting landlord. There is no bar under section 116 of the Evidence Act. I can challenge, Lordship, only, and
you have raised that point in the suit. Ownership is not necessary.
Ownership, I am not disputing the ownership. Only one thing, pretrial amendment, those facts needs to be incorporated, that the title suit, which is subsequent event also, and trial has not yet been commenced, Lordship. Kindly consider, kindly allow that portion only. 6, Lordship, 6E portion, that is pretrial amendment, subsequent event, Lordship.
This application under Article 2
18.
And I am for the
Father opposite.
Father of
Father of the child, not custody.
custody. Yes.
My lord, my petition made under section 17 of Guardianship and Wards Act, my lord, was turned down by the learned court. That is why, my lord, I have come before your lordship. My lord, I made an application so that the minor son, aged about 16 years, can depose before the learned court.
Can
Depose. My lord,
is it about
16 years. 16. Age of well understanding, my lord. And that petition, my lord, was turned down. And so that, my lord, I have come before your lordship. It's a very simple matter.
child is with whom?
My lord, with myself, mother. When he was only,
Show me your application and the
yes, my lord.
petition dated 27th of January 2025.
Yes, my lord. That is, my lord, page number 17. 16.
Both
Start-
of you fight between yourselves.
Yes.
Why are you using the child for this purpose? Why are you using the child for this purpose? Both of you fight amongst yourselves. Nobody will stop you from fighting. You fight amongst yourselves. Why are you using the child?
Well, not using the child, my lord.
Yes.
Child's, my lord, for
You are
the just
using the
decision
child.
of the case, my lord, his deposition is required, my lord.
That the court will consider whether his deposition is necessary or
Well,
not.
court has considered and rejected. That is
Yes,
why, my
yes.
lord, I have come before your lordship.
Show me the petition dated
Yes, my
27th
lord. Page
of
number 16, my lord. Annexure C.
evidence concluded.
Evidence concluded.
Partly argument held.
No, my lord. At the time of my lord, date fixed, my lord, I raised this objection and preferred this application. And that was,
1st of March. What happened on 1st of March?
That is the part of argument should be.
well,
made
next
by
date
the-
is next date is fixed on tomorrow, my lord. 11th.
Tomorrow, make the arguments.
No, my lord. Kindly,
If tomorrow it is hard,
my lord,
it
my
will be decided.
my lord, for it is written, my lord, if minor is old enough to form
Child is with you.
intelligent preference, my lord. But
Child is
his
with you.
evidence is required, my lord.
Child is with you.
I do not want to disclose other facts, my lord,
No, no,
but
no.
his evidence is required.
You need not disclose. Child is with you since when?
Since when he was only 2 years old. When he was only 2 years old.
His evidence is not necessary. His evidence is
One
not
date is
necessary.
required, my
It will
lord.
be a
Only
tutored
one date is
evidence.
required.
It will be a tutored evidence.
No, my lord, not tutored, my lord. They will find scope to cross-examine the child, my lord. So, my lord,
That is why I told you. Don't use the child in
no,
the fight
I am not
between.
using the child, my lord. My lord,
Uh,
my lord, only one date is required, my lord. If necessary,
for what?
for the deposition of
You
the
complete your argument. You complete your argument, the court will decide.
nobody will be prejudiced. Nobody will be prejudiced.
Child will be prejudiced. None of you will be prejudiced, for sure. Child will be prejudiced.
But
Child will be prejudiced. None of you, both of you are fighting, none of you will be prejudiced.
what
You
behavior
fight,
he
both
has
of you
been
fight.
experiencing for the last 12 years, my
Yes,
lord,
yes.
14 years, that he will say, my lord, he wants to say, my lord, before the learned trial court, my lord.
Not necessary. It's the court. If the court feels, court has ample powers with regard to that.
And in many judgments of Honorable Supreme Court are, and also in this court, my lord, the child's intelligence was tested and thereafter, my lord, conclusion was made. In many cases, my lord. Your lordship knows better than
If
me.
you
my
want,
lord.
I can post it for contested application, but without staying the proceedings.
Yes, my lord.
I can.
Yes, 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 yes.
The learned advocate appearing for the petitioner
Lord, an application for police help has been allowed
Has
without.
been allowed rightly, Mr. Gupta. You are violating the order of injunction. What can be done?
Actually, neither I have been served with the copy of plaint, not amended plaint, not amended injunction application, not copy of application, and all these things have been done, my lord, unilaterally without even making me aware
Police
that
help also ex parte.
everything. For that, my lord, I obtained order sheet.
Mr. Gupta, this was an order of 18th of November 2024.
My lord,
What are you doing?
my lord, paragraph 14, just now a letter has been given to me.
What are you doing?
What I am doing? Defendant number 3, I am the owner of the entire property. The plaint case is paragraph.
What are you doing? You are constructing.
No. The allegation is the petitioner has approached that he happens to be my licensee. But I have never inducted him his licensee. Paragraph 4 of the plaint, page 17. I am the owner of its 168 kata of land. He says that he is a licensee under me. No relief against me. Kindly turn to
So
me.
how are you aggrieved by this?
I am coming, my lord. Page 23. Kindly have a look to the relief claim. He is claiming a relief against defendant number 1 and 2. They are his setup person. I have been impleaded, page 16, as pro forma defendant.
So,
it's a pure
so how are you affected?
fraudulent suit. Kindly have.
But how are you affected, Mr. Gupta, by this
Because
order?
I can't, my lord. There is no stall of 12,000 square feet. The case is that as if I have inducted him in a stall of 12,000 square feet and no relief against me, no. Even
So, injunction application has not yet been served.
nothing. I have obtained a copy of order. Kindly look to this. Even compliance was not secured upon me because I am pro forma
Mr. Gupta,
defendant.
learned
Kindly, 1 minute it will take. Kindly have a look to the relief.
You
And
please
if it-
go through that. Come back tomorrow with instructions.
This is not a dispute in between Monglahat Company and Boshundhara. This is a dispute. The suit is by a stallholder against the owner claiming that he happens to be a
All right, you come tomorrow after consent. If you say yes, I can
Your
take up.
Yes. Or your lordship. Whether
Yes. Call the next matter.
I understand considering the scope of the suit in this, there would be no.
If there is no
Had-
difficulty on
had
my
it
part,
been a-
I can.
Had it been a dispute interseen between owners, I could not have, my lord, in any way. said your lordship to take up. But however, my lord, it is for your lordship.
Yes, yes. Yes, Mr. Banerjee.
Mr. Kaur is leading me.
Seeking leave to appear virtually. Before
Yes,
your lordship.
Mr. Kaur.
This is an application under section 24, seeking transfer of a matrimonial suit, filed before the learned additional district judge, Fourth Court, Purvo Bardhaman. Briefly.
You are the husband, Mr. Kaur.
Yes, yes. I am for the husband, but under an extreme circumstances, this application is being filed.
Yes.
What had happened is that the marriage was solemnized, sometimes in 2016, and then, the matrimonial home was in Belfast, North Ireland. The parties residing there, when the wife, left, Belfast, sometimes in January 2022. Now, the problem is that
Marriage took place where?
in Calcutta, in Bardhaman, 2016.
So 2016 marriage is in Bardhaman.
Yes. Then
where the suit has been filed. Where the suit has been filed. Yes.
Yes. Now, the problem
But according to you, the parties lastly resided outside the jurisdiction of Bardhaman court.
Yes, they were all along. From 2017, when she moved to Belfast, parties were in Belfast itself. That has been their matrimonial home. In fact, your lordships will find the address of the petitioner. That had been the matrimonial home. Now, the problem is, I tell your lordship very frankly, that the father of the petitioner, he is the principal witness, because there's an allegation of torture, etc. He is aged 73 years and has some health issues. So for him to come down to India and travel to Bardhaman is very difficult, because it's about 9,652 kilometers between Belfast and in Calcutta, and then from Kolkata to Bardhaman, and staying there, it takes about 20-25 hours travel time. And apart from that, some Irish friends who were closely associated, they are also required to give evidence. Now, to carry them from Kolkata to Bardhaman is going to be a big issue. And thirdly, the most important aspect is, if your lordships kindly come to paragraph 16, 1-6.
Yes.
Your lordships may kindly see, even after the suit was filed, now written statement has been filed on behalf of the husband. Now, even after the suit was filed, what had happened is, during the marital time when they were together, there were frivolous complaints, filed before the police there in Belfast, for which, he was called, he was detained, etc. Now, even after she has come back, there are filthy, messages which are being sent. And there is an apprehension that, they are influential people in Bardhaman, that, there may be, physical harm. So, this is basically, and the apprehension is, in para 16, your lordships will kindly take note of. I am saying, kindly issue a notice. At least, let them come. And I am saying that it can be transferred to a neutral place, family court here in Calcutta, or city civil court, or even to the district judge, South 24 Parganas, or somewhere closer by, if your lordship so feel.
Mr. Kaur, anyway, the principal witness, who is the father of the petitioner, he has to travel to Calcutta.
Kolkata,
So
yes.
that cannot be. So
Avoid.
it's only for the days of these giving evidence by the father.
Yes.
It's the father who has to travel. Otherwise, who is conducting the proceedings before the learned trial judge? On behalf of the petitioner.
Proceedings before the learned trial judge, Mr. Das or Mr. Banerjee would be able to assist your lordship. There is a local lawyer engaged, but they are the ones who are.
Lawyer, but I find that affidavit, it has been affirmed by the constituted attorney.
Yes.
I think he is looking after the case.
Correct.
It's only on the day when the
Clap to Mr. Dash. Well, that was the difficulty. He is just Miller clerk to Mr. Dash.
But he is the constituted attorney.
true. Miller, there is a
Somebody,
power of
Mr.
attorney.
Banerjee, has to take care of
True,
the day-to-day proceedings.
Miller, with
So
the
the
kindly
father
permission
of the
of all,
petitioner has
I can
only
indicate one thing.
to come to the court to lead a
He himself has to come. The petitioner himself has to
Yes.
come. Lord.
petitioner
So-
himself has to come, the father also. So we can request the learned trial judge to fix consecutive dates for their evidence.
There is Miller one more thing with Miller.
Because they have to come, considering the fact that they have to travel out from outside the country. So consecutive dates in advance can be fixed.
Lord, only thing I was apprehensive that, Lord, the personal issues which are reflected, Lord, in para 16, and in fact, I can show your lordships the kind of messages that has been received even in recent times. In fact, Mr. Das is having, Lord, these messages. Your lordships can kindly look into this, but I am really hesitant to show your lordship these messages.
You did not know, you did not place those messages, but the only fact remains that because the suit has to proceed, the evidence will take some time. Only you have filed your written statement.
Sir, that may not be necessary since now both the parties have agreed for divorce, sir, divorce. Joshua intervention.
I don't have the update. Yes.
Both the
Please.
parties Millard have now possibly principally agreed to go for a divorce. That is not in black and white. Wife has filed a suit for divorce. We had a talk with the husband also. Husband is also no more willing to carry it along. So with my lord's intervention, these two young lives, that can be saved, and they can move on from here. So kindly allow.
Banerjee, if both of them want, so they can file an application under
Kindly,
section
allow
13B or
my
under
lord's
which-
presence in that would help us.
No, I
Kindly,
tell you, Lordship,
notice, kindly allow them.
Why are you involving the court? Mr. Kaur is there.
No, Lord, what he says that it might facilitate.
Above all of us.
Yeah. It might facilitate between the parties to come to a amicable solution. I didn't know about this development. So,
All
Your
right, so
Lordship,
I'm directing you to serve.
Yes.
yes.
So shall I record this that there is a possibility of settlement?
এখন দরকার নেই স্যার, এখন সেটা রেকর্ডের দরকার নেই, ওনারা এসেই বলুন, নিজে থেকে বলুন।
Very well.
This application under section 24 of the Code of Civil Procedure is at the instance of the husband who claims to be presently residing in United Kingdom, praying for transfer of the matrimonial suit number 703 of 2024, presently pending before the learned additional district judge 4th court at Purba Bardhaman to the court of the learned district judge 24 Pogana South at Alipur. First up, after hearing Mr. Kaur, learned senior advocate for the petitioner, this court is not inclined to pass any interim order at this stage, considering the fact that the proceeding is being looked after on behalf of the petitioner by a constituted attorney, and only the written statement has been filed. First
And
up,
accepted. And accepted.
written statement has been filed and accepted. First up, petitioner is directed to serve a copy of this application upon the wife opposite party hearing by registered speed post with acknowledgement due and file an affidavit of service on the next date. List this matter under the heading contested application in the monthly list of April 2025.
And also upon the learned lawyer who is representing the wife there.
Wife as well as upon the learned advocate representing the wife opposite party hearing before the learned trial judge.
May there be a stay of the matrimonial suit in the meantime?
Stay-
I think it's going to happen otherwise also.
They not necessary, since you have said there is a possibility.
Much obliged, much obliged.
Only written statement file constitute, that is for the, I have recorded the reasons for not passing any order. Yes, Mr. Banerjee, where were you?
Could not.
Thank you,
come at the time of call, my lord, kindly,
What is the item?
item number 13.
1-3.
1-3.
1-3 টা পাঠিয়ে দিয়েছেন? Just come. After this,
Caveat has to be filed. Caveat.
caveat,
Take this.
you have not solved the caveat, or why, Mr. Banerjee?
Yes, I cannot come.
Item number 13.
13.
পাঠানো হয়েছে, একটা অর্ডার রেকর্ড করে নিন তো, আইটেম নাম্বার 13।
21.
21, my lord, Mr. Bhattacharya is appearing on behalf of the petitioner.
Since I'm not inclined to take up this matter on personal.
My,
Yes,
my,
Mr. Mukherjee.
my client filed a suit for declaration and injunction and recovery of possession. Suit was in 1985. Suit was decreed, appeal preferred, appeal dismissed, second appeal dismissed, 3 section 47 dismissed.
Dismissed. This will be dismissed.
Now, my lord, what happened, my lord? This honorable court directed.
You are still now moving expeditious hearing matters. This up, dismissing this.
এখানে আয় পে একটা ফটো পে একটা ফটো পে একটা ফটো এটা পে
What is the miss case?
My lord, my miss case order 9 rule 9 case number 110 2024.
Yes, under what provision this miss case was filed?
Order 9 rule 9 of
Order 9, Rule 9.
yes my
dismissed for default. It has been dismissed for default.
my lord, it has been dismissed for default.
Suit was dismissed for default.
Suit no my lord. Execution
Execution cases.
Execution case was dismissed for default.
yes
Ashun. This application. Service returns.
Kindly see
NAD.
yes, kindly see my lord page 10 once.
Yes.
Or rather my lord page 12.
Yes.
But kindly see Sanjeev Seth.
Yes.
Now kindly turn to my lord page 10. For whom he is appearing, Manoka Dhara, Shankar Majhi, and Gauri Patra. Then my lord kindly see the next order of this honorable court. But page 16. Kindly turn to page 17.
But service of this miss case that is.
One person has already appeared. 2 person is avoiding the summons. They are receiving there.
You have to take steps, Mr. Mukherjee. How can this be disposed of without the miss case being ready for hearing?
Whatever I want to show you the conduct.
I appreciate that conduct, but unless this SR and ID, how can I direct the
one out of the 1 person has already filed objection. But as expeditiously kindly direct my lord, so that
service, unless service is complete?
service, my lord, I have been told.
I cannot direct expeditious hearing. Evar Devjit Mukherjee naamta likho.
Then my lord, kindly do one thing, my lord, kindly because my next date kindly see.
Sir Mukherjee, if you understand why are you saying that?
Only thing kindly see the date what has been given after 6 months. But kindly see.
What after 6 months?
7 February was the last date.
Now is not 6 months.
Yes, 2nd June.
Yes, 2nd June is.
2nd June, my lord, 11th February was the last date.
Preponing, I will give you liberty to apply for preponing. Mr. Mukherjee, that cannot be done. You are saying yes, yes. This is the date fixed for service returns. Can it be preponed?
But service return 3 times it is.
Maybe. Can it be preponed?
If I apply my lord, showing
Can
that
it be-
service has been completed.
How do they know? They will be knowing that 2nd of June.
Then my
I'm telling you, you are saying yes, yes.
permit me to serve copy of this application. They will come. They will
23.
23, my lord, I am for the petitioner. This is an application for expeditious disposal. The plaintiff petitioner
Of
have
what?
filed a money suit in the year 2020.
What is the stage of the money suit?
Evidence of PW1 is going on, my lord. But if your lordship kindly takes up the orders, your lordship will find on every
This
occasion
application under Article 227
defendants
of
are
the
praying.
In 24, my lord, I beg to appear for the petitioner husband, my lord. My lord, I am challenging in the instant revisional application the order passed under section 24 of Hindu Marriage Act, thereby granting alimony pendente like to the opposite party to an amount of rupees 10,000 per month by holding that my monthly income is 15 lakhs, my lord.
15 lakhs? Where is the finding?
1,50,000. My lord, kindly come to inner page 2. Middle part, upon perusal of the petition under section 24, Hindu Marriage Act 1955, supported with affidavit, it appears that the respondent has pleaded that she has no independent source of income, thus she is unable to maintain herself, whereas petitioner husband earned more than 1,50,000 per month. The respondent, that is petitioner of the petition under section 24 of Hindu Marriage Act, has prayed for 20,000 for herself and rupees 10,000 for her minor child, and 1 lakh as litigation cost. But my lord, my case is that the learned court below did not consider the fact that wife instituted 125, where I am paying her 3,000. I have disclosed in my asset liability. Now, my lord, petitioner is a junior advocate at Raghunathpur court. Now, my lord, 10,000 in his asset liability, he disclosed that 15,000 per month his income. Now, 10,000 he has been directed to pay. Let me, my lord, serve and come back, my lord.
Where is the order passed under section 125?
That, my lord, I did in annex, my lord. So, but my lord, I have disclosed in my asset liability, my lord.
Maybe you have not taken this point.
My lord, kindly come page 57.
If they come, it may be enhanced. 1,50,000, only 10,000.
It is case of the opposite party. In my case is not that. My case is 15,000. The learned court below.
How long you are practicing?
My lord,
not you, your client.
I got instruction 8 to 10, my lord.
8 to 10?
10 years.
So it's not a junior advocate.
My lord, 10,000, my lord, it's too.
So you are taking this risk. Show me your assets and liabilities.
That I have stated, my lord. Kindly come to page 56.
56, yes.
Point number 8. Monthly income 15,000.
What are the assets which you are owning?
Nothing, my lord. No landed property, nothing. And my lord, kindly page.
2-wheeler, 4-wheeler?
Nothing, my lord.
Where have you said that you are not owning anything?
My lord,
with regard to 2-wheeler and 4-wheeler?
57, my lord. Point number 18. Regarding the
Where is your income tax return?
Nothing, my lord. No, no income tax return. No income tax return.
You are not filing your income tax return.
I don't have income of that much, my lord.
No. You have some income, may not be 1,50,000.
10,000, I will not come under that income tax category, my lord.
10,000 is your income.
15,000, my lord. If I go by the asset liability filed by me, 15,000, my lord, I will not come under the, my lord.
15,000 that you have stated. What are the bank accounts which you have produced? You have not furnished any bank account.
Page 62.
62.
Point number 1. Details all the bank accounts, including current savings, 25,000 savings, and account number I have disclosed. Then she did not dispute my asset liability.
Where is your written objection?
My lord, written objection, my lord. I have annexed, my lord. But kindly come to page 29.
29.
It's handwritten. Thereafter, my lord, I have filed additional WS that will, your lordship will find out page 34. That is typed, my lord. The wife only filed the husband filed this matrimonial suit in the year 2023. Marriage is of 18. Wife is not residing with me. That is why, my lord, I filed.
Where have you stated that your income is rupees 10,000 per month?
In my lord,
Objection.
My lord, kindly come to page 43.
43.
Para number 23. Additional written statement which I have filed before.
No, not additional written statement. In the objection to section 24.
Yes, in 24, my lord, I filed additional objection. That
Additional written objection. So in the main written objection, you have not stated your income.
I don't know, my lord. He filed, my lord.
So you become wiser after that.
My lord,
where is that?
It's start with page 34, the additional written objection. My lord, whatever query, my lord.
So it starts from 34 to 43. Initial objection is of 2 pages.
My lord, page
and additional written objection is of 10 pages. More than 10 pages.
That is filed by me, my lord. I can't deny that fact. My lord, page 44, point number 24.
What is your income, you said?
Not more than 15,000.
Not more than 15,000. Page 50 is your affidavit of asset.
No, my lord, that is wife. My start with page 56.
56. Your monthly expenditure is 12,400.
My lord, it's written, my lord.
So monthly expenditure is 12,400. Your income cannot be 15,000.
My lord, come back, my lord. May I come back after?
Your income cannot be 15,000.
My lord, this is disclosed in my asset liability.
That is why I'm on that. If I accept your monthly expenditure, income cannot be accepted. And if income is accepted, monthly expenditure cannot be accepted.
I have to take instruction whether any loan is there or not, my lord. That is not
loan for purchasing what? 4-wheeler, flat,
that
what?
Is not, my lord, appearing from the asset liability. I have to take instruction.
You are taking this risk of serving. They will come, they will file for enhancement. Ashun, the learned advocate
This is my application for expeditious disposal, Lordship.
Of what?
Of a ejectment suit filed in 2023, Lordship.
What is the stage?
Stage is for peremptory hearing, Lordship.
Peremptory hearing.
Lordship.
7-2, what happened?
Lordship, it was dismissed.
7-2 dismissed.
Lordship, because statutory tenancy, that is my only thing, that statutory tenancy has been over and no payment has been made yet, Lordship. Lordship comes to page 10, Lordship will find 2 grounds which are stated.
No, show me the order rejecting 7-2.
Lordship. Lordship, that would be Lordship order number 5 dated 12/3/2024, Lordship.
Order number 5.
12/3/2024, Lordship.
No, which order?
Lordship, order number 5, 12/3/2024, Lordship.
Order number 5.
5, Lordship. Last but 3 pages.
12th of March.
12th of March, Lordship.
Order number 5 is not here. Oh, yes, after that.
Lordship.
They have not challenged this order.
No, Lordship.
Ashun. This application under Article 227 of
the petitioner before your lordship. Lord, kindly see once, Milord, without looking into it. It's expeditious, but Milord, why, Milord? I'm telling you, your lordship. 1988 deed executed by the father. Milord, in 2015, Milord, 2021, the development agreement executed. Once looks at page 85. This is the construction come up. In 2025, Milord, a suit is being initiated and ad interim order passed. Immediately on the day of my appearance, Milord, I filed an application for vacating. Kindly see, Milord, now the order sheet. The court has posted in the month of June. This is the stage of construction, page 85. I have been restrained from, Milord, now changing the nature and character of the suit. Page 85 is the construction starting from 2021. My brother has filed the suit. He asked for his share from the promoter. Now, my lord, he challenged the
Brother or brother-in-law?
brother.
Brother or brother-in-law, I'm asking. Brother.
Lord, it's the exclusive property of mine. 1988 settlement deed.
2nd June.
Absolutely frivolous. Lord, 2nd June. Lord,
I cannot allow the order 39 rule for from here.
I'm not saying that. Lord, kindly takes up the previous order. Lord, 29th is the compliance. 5th of Lord, February, I appeared. File application under order 39 rule 4. In a routine manner, Lord, kindly see the last order. Kindly direct, Lord, this application to be disposed of within a month. Lord, my construction is at this stage. I have been restrained, Lord.
You have filed your written objection to the injunction application.
No, I have filed, Lord, order 39 rule.
So this will be treated to be an objection to the injunction application.
Does that, Lord, does that everything has been, Lord, annexed to that? Everything.
From directing that you will not be filing any written objection, this order 39 rule 4 will be treated to be an objection against order 39 rule 1 and 2. If they choose to file any counter to this,
Everything
after
let that be done, Lord, within a time bound process. Lord, kindly do that.
Ashun. This application
2 and 3 pass over matters.
না অর্ডারটা দাও। Yes, Mr. Banerjee.
Lord, we had deposited the requisites. It had come back unserved. It had been fixed on the 21st of March, Lord, for taking fresh steps. We had deposited, that was my Lord's queries. And we had-
Lord, my submission with regard to this is point of law. How judgment debtor shall be necessary, no, how he is interested with regard to this judgment debtor. Order 21 rule 97,
maintainable.
Order 21 rule 97 application against the degree holder not to execute the decree because I am not bound by the decree. Lordship kindly look at the judgment.
Raise that point. I will.
No, kindly.
21st. Raise the on the you are on the maintainability of the case.
No, I have served the copy. He was served.
No.
I was directed to serve the copy to the judgment debtor here in this case.
Yes.
Service was that it was duly effected.
Yes. They have not come now.
Therefore, so far his service is concerned, may be dispensed to it.
Yes.
He did not contest.
I'm directing the miscase.
And another thing, my lord, another thing, that I have taken a point, Lord, if your lordship kindly come to the impugned order.
Yes.
Lord, after 1, 2, 3, 4, since this is an appeal, Lord, kindly look to
steps upon the opposite party. Number 2 is the judgment debtor.
Judgment debtor. Lord, kindly look to the ordering portion only before ordering portion. Since this is an appeal under order 43 of the CP code, the provision of order 41.
Which order you are placing?
The impugned order.
Order dated 22nd of February 2024.
Lordship.
Yes.
Before the ordering portion, since this is an appeal.
Before ordering portion. Yes.
Under order 43 of the CP code, the provision of order 41 for furnishing security shall not be applicable. And in order to ensure that the miscellaneous appeal could be disposed of expeditiously, conditional stay shall be granted for ends of justice, or also the appeal will be frustrated. Hence,
the condition is that it will be no adjournment will be granted.
No adjournment. This question would be, my lord. Order 43, this is not an appeal under order 43. This is an appeal under section order 21, 103, dim degree.
103.
Therefore, he says the order 41 rule, order 41 will not apply. Therefore, order 41 rule 5, I will not impose any condition. Although I filed an objection that for his unauthorized occupation, he is liable to pay 1 lakh per month. Lord, as a condition precedent for that grant. That is why he did not enter into that question. Therefore, what I want, my lord, lordship kindly direct the stay application along with my objection to decide that.
Mr. Banerjee, that will delay stay application. Otherwise, I am directing the miscellaneous appeal to be disposed of. You raise your
without paying any farthing, my lord, they will.
If you
enjoy the property, Mr. more than one biggers.
All right, if you want, I can direct the stay application to be heard out. No problem, no issues on that. If you insist
within
on
a month, an appeal within a month thereafter.
Mr. Banerjee, you know very well what will be the result of the stay. Then another round of litigation here. That is always there. That is why I asked
always there.
So, if you want, I can direct stay application to be heard. That can be done.
Yes, your lordship kindly, because I have taken instruction on this.
So I'm directing the
stay application we have.
So stay application. It has been fixed on when? Stay application?
21st March.
Stay application.
Yes, Lord. There is an introductory application, Lord, of amendment as well. That
Lord, order. Their application, your lordship kindly come.
No, it has been, yes, for hearing of the petition. This is the stay petition.
Stay petition and amendment.
What amendment?
At order 6 rule 75, sir.
Who has filed that?
I have.
Application.
Order দেখ?
No.
Ashun.
No.
Order দেখ?
Lord, your lordship, stay application.
দেখি। দেখেছি
ঠিক আছে লর্ডশিপ কাইন্ডলি yes stay application lord at page 84 and objection 87
এই যে স্যার এটা আমি কি করে বলবো ফাইল রয়েছে
না তুমি কেউ তো জানে
তা আমার আমি জানি না
for for amendment of what
সেটা আমি কি করে বলবো
no his clients are present he is their lawyer we are not served with the copy kindly look to the order how they are because if your lordship direct to decide the appeal on merits that cannot be done
order 6 rules and
lordship kindly look to the order chief
So I'm directing the stay application to be heard. Because stay of the execution. So that is to be heard. Thereafter, let the amendment, all other interlocutory applications be heard.
and my lord
And the miscellaneous
this observation be set aside because this is not an appeal under order 43 absolutely wrong
Where is your stay application?
lord a stay application it has
Page 87.
page 84.
No, 87 is the objection.
84 my lord
84.
stay application
তাহলে adjournment আমি নিতে পারবো না কন্ডিশনটা চলো
And this is your objection.
and this is my objection
87.
yes lord paragraph 13 and 14 89 kindly come to paragraph 89 paragraph 13 14 page 89 did not enter into the merits because order 41 will not apply order 41 rule 5 absolutely wrong order no documents
the statutory I have a right whether there is any condition or not that is something which is a different thing altogether the learned judge has put a different sort of a condition so that they are not accepting that so I will take adjourn I am not under the law that gives me a right to take adjournments now the question is Millard whether Millard on at a stay application stage they will have to go into the merits and then decide no
No, not a question of going into the merits.
so that the learned
Stay application, not a question, but the question is whether this is an appropriate condition or not. That is to be considered.
Absolutely. Now, if my learned senior friend says it's not an appropriate condition, it has to go back again for whatever it is.
Yes, it has to be directed to be heard.
lord in supermax case my lord supreme court laid down the law in all cases like whenever you are no discretion shall be exercised
And directing the stay application to be heard.
right. No further argument
This application,
27. My lord, may I seek your kind indulgence, my lord? My lord, item number 40, I had mentioned on previous occasion, my lord, that it was adjourned because the counsel for the respondent was not there, my lord. Today, the matter was taken up and order has been passed, my lord, against us, attaching the property, my lord. Kindly, it's item number 40 running list, man, today. Kindly take such matter.
I don't know what is the urgency. I don't know.
My lord, urgency that
I don't
order
know
has
why
been
are they
passed.
mentioning?
My lord, the matter has been taken up and
Get the list today, item number 40, 41.
if it doesn't go to the item number 40, kindly takes it up.
How
my lord.
mentioning, I don't know. What's the
My
urgency?
lord, is the urgency?
Please wait, sir. Yes.
Absolutely, my lord. Oh, sure.
Much obliged, man.
May please lordship. Not I am for the petition in the matter, not against the order of preemption. Preemption, the mispetition has been ex parte rejected. And against that order, appeal has been preferred by the preemptor. That appeal has been allowed. And you also can see for a moment the order of the appellate court.
Appeal has been allowed.
By the order. Appeal has been allowed. Well, can you see?
Last order.
My can you see my big order? May I am paying people lots of also go through the order, the Borgadar. Well, owner expired. Now the Borgadar, the heirs of the Borgadar, they transfer the property one time. Again, another Borgadar, co-Borgadar transfer. Now I purchase the property from the third transfer. Now how preemption lies, I don't know. You know, go to order for a moment. You watch it. What actually I feel good order. My can you see for a moment? I'm sorry, I cannot disturb your lordship. Big order when I said. What actually? My lord. The judgment portion, your lordship, kindly the appellate court, whole lord in this session. The Borgadar, my lord. Second time.
Where is the trial court's judgment?
My lord, just before.
There's been a land reform.
My lord, trial court order. Lord, page 23. Page 23, my lord, page 23, annex at P3. Order dated, page 23. Trial court order. Annex at P3.
Rules, act.
One mortgage, one transfer, second time transfer, third.
You have a copy of the Land Reforms Act?
My lord, I've got, that is old.
Yes, I've got.
Section 8, my lord. I have, you have also got, I think, Lord, the section 8 of the land contract. I've got it. Of the right.
Where is the trial court's judgment?
My lord, page 23. Page 23, annexed at P3. Page 23, man, for a moment, you know, I'm annexed the entered judge. Annexed P3, page 23. And the judgment of the order dated 34 dated 21/7/2030. Man, this is the order. The fact of the case, man, or the observation of the trial court. Trial court may rightly observe. But the PMSN case has been expertly dismissed, rejected. Rightly passed as an order. The appeal court may not the three deed, I'm not disturbing your losses. Evidence on record. Three original deed. One, second certificate copy of the deed. Two, third certificate copy of the deed dated. Exhibit 3. 3 exhibits, you know. Thereafter, decisions of the regents.
The transfer was made to the Borgadar.
My lord. That is the deed in question. You are also calling the Borgadar, my lord, by virtue of Borgadar, they admitted.
Show me your objection.
Yes. Well, I annexed the objection, my lord, I'm coming. I'm sorry, my lord, I'm coming. I'm annexed, my lord. Annexure, my lord, page 19, P2. Annexure P, page 19. And can I see, this is my affidavit of opposition, my written statement. Page 19, P2. Bengali, my lord, written, I'm sorry.
Page 19.
Well, yes, 19, annexure P2. You have also got it. That is opposition.
Yes.
Our opposition, my lord. The Bengali written, Bengali, you also can see. বাদীপক্ষে দরখাস্তের বর্ণনা মোতাবেক শাহাদাত আলী ফকির পূর্বতন মালিক থাকিয়া দাবাদ উদ্দিন মন্ডল তাহার অধীনে বড়গাদা থাকাকালে তাহার মৃত্যুর পরে তাহার 3 পুত্র দলিল বলে শাহাদাত আলীর ওয়ারিশগণের নিকট হইতে দলিল বলে যথাক্রমে 39 শতক খরিদ করিয়া এই স্পষ্টমূলক ইবি বড়গাদার দে আর দি after death the son how they become raj I don't know, my lord. It is the duty of the son to thereafter, my lord, ভোগদল করিয়া থাকালীন 30/3/15 তারিখে নাবালক মরসুমের অভিভাবক পিতা ইলিয়াস আলী সর্দার 3 শতক জমি অফিস উদ্দিন মন্ডলগণকে বিক্রয় করিয়া দিবার উক্তি কি হঠাৎ 2015 সনের এপ্রিল মাসে 1 শতক সম্পত্তি মান্নান সরকারকে লক্ষ্য করেন যে নালিশি সম্পত্তি দখল লইবার চেষ্টা করেন এইরূপ উক্তি কি তৎপর গোলযোগ হইলে তাহারা 30/3/15 তারিখে লইবার বিষয় প্রকাশ করিলে তাহার নকল তুলিয়া বাদীপক্ষ প্রথম জানিলেন যে তাহাকে কোনো নোটিশ না দিয়া প্রদান করিয়া বা না জানানোর বিষয় বলিবার কথা এবং প্রার্থী পূর্বেই দাগের অংশ খরিদের শরিক এন্ড লাগোয়া মালিক হইবার উক্তি কি বিবাদী পক্ষ
My lord, this matter, Mr. Uttiyo Rai appear on behalf of petitioner, my lord, due to
Yes.
some personal difficulty left the court, my lord, only not today, my lord.
This matter was adjourned on the last occasion. Also,
I don't know, my
his sister appeared.
my lord. My lord, I don't know, my lord. Only he request him to over telephone, my lord. Only not today, my lord.
This application under
But to, my instruction is so that my client wants to file opposition, your lordship, to their petition.
file opposition to what?
To their petition, your lordship. The revisional application.
Civil division application. What is this matter? Civil division application, you want to file opposition. Why?
But,
Yesterday
I was
constructing a multi-story building over the suit property encroaching upon my land. They have nearly completed 9-story building simply to delay the proceedings of the
that
suit.
encroachment, whether there is
In a suit for injunction, simpliciter against the sole defendant. Now,
Why do you want to file opposition?
that is the instruction that I have received from my learned advocate on record, your lordship.
That you may have. You are the arguing counsel.
Yes, your lordship. But
Yes, what is this matter?
in a suit for
The
permanent.
civil division application, rarely the directions for affidavits are filed.
I understand, your lordship.
Yes, yes, sir.
suit for injunction against the
Please use the microphone.
suit for injunction against the sole defendant.
Against?
Sole defendant. Pleadings
Yes.
are completed. They, in the mean, ad interim injunction was passed in the matter on 6/11/2006, and order of permanent injunction was passed on 6/11/2006.
Yes.
In the coming into the year 2022, they started to take steps for construction of a multi-story building over my suit property. violating the injunction order. We have filed an application for execution of the injunction order for reasons based known to the matter.
What is the
still
impugned
pending.
order? What is the impugned order?
Impugned order is the trial court has allowed their petition under Order 1, Rule 10.
Their application
Their
for order 1,
application.
Rule 10.
They sole ground in that application for addition of party is that because one of them, against one of them, a writ petition was filed in the High Court at Calcutta. That is why he is required to be added as a
All
party.
right, give me a minute. Where is the application for addition of party? Where is the plaint?
Page 87.
Where is the plaint?
Plaint is at page 20.
No, 20 is after order 1, Rule 10 has been allowed.
No, my lord.
Yes, yes, yes.
Revised plaint after allowing order 1, Rule 10, that is the caption at page
This
20.
is after when applicant number 1 and 2 was subsequently added as a party. That revised plaint is this.
Where is the application under order 7, under order 1, Rule 10?
87.
87. 87.
Yes, how are you a necessary party?
But my legal right has been infringed.
Why?
Because, may not kindly
You
consider,
file a suit, separate suit.
not kindly consider. The actual,
What is the legal right you have?
the actual opposite party, Shopon Go Thagurata, is the son-in-law of the Khagendranath Roy, who is the father, who is my father. Now, after his death, along with Tapon De, your lordship, if your lordship kindly comes to the impugned order for once. Along with Tapon De, he was survived by Kamala De Sarkar, the daughter, Usharani De, the daughter.
Which is the property in respect of which you are claiming title? What is the property?
That is where, my lord, I need some instruction, because that is where I need some instruction, my lord. I could not sit with the client yesterday because he's out of town.
You did not say so.
My lord,
You said why you wanted to file
That is-
affidavit in
that is the-
opposition.
that is the-
Unheard of in a civil division application.
that is what my learned advocate on record asked me to submit. Your lordship, if your lordship kindly adjourns it for a week.
Will not permit me to say one thing. By their affidavit and by their written statement,
When
they
this
have
matter is
declared
taken up
that
for hearing, the learned advocate appeal.
order should be stayed. Otherwise, I
But
shall
next
have to
day is-
file revised plaint.
My lord, next
But
day is the
It is
first
pending,
of
nothing
April.
will happen. Yes.
The,
Next.
the learned trial court has made
What is
an
the
order
next date fix?
1st April.
1st April.
13th of March, I am fixing.
March, right, my lord.
Yes.
Lordship, item number 30, I beg to appear online, my lord, I am on legs elsewhere. My lord, I have been served with a copy of my lord's order passed in this CO, but I have not been served with a copy of the application, nor do I know if I am
For the
included as a party.
I made an unauthorized construction and an order of demolition, my lord, was made by
Mr. Banerjee, you have not served a copy of the writ petition.
not a
By
party.
civil.
She's not a party.
Then why was a copy of the order served
I
to
will
me, my
serve the
lord?
honor.
She appeared in contempt where the
Maybe
municipality.
if she is not a party, why have you served a copy of the order and not the application?
No, not it's we haven't served a copy of the order on her. She has gotten a copy of the order from contempt proceedings taken out by her before this honorable court, and she's
Then
appearing.
this order must have been
I have served along with the
produced.
applications. I have also served
This
my lord,
order of
all the
This
pleadings
order of
and
my
the
lord must have then been produced in the contempt proceedings before my lord Justice Sinha. The order of demolition is at my instance. I have sought implementation of the
against which I have
demolition order. There is a contempt proceedings
there's
pending.
order
I
of
received
demolition
this
against which there
order.
At her instance.
yes.
So she is a necessary party.
My lord, there's a judgment, my lord. Sanjay Mehta.
Mr. Banerjee, serve a copy upon her.
She's not a party.
And also,
But your lordship will add her if your lordship wants to.
I am praying for formal implement in that case, my lord.
Make her in party in the appeal.
Yes.
But at her instance, this order of demolition was passed.
So in
Yes,
the
my
appeal,
lord.
You ought to have made her a party in the appeal.
yes, there was this view. Now after, my lord, the privacy judgment, my lord, I think that they will have to make out a case after the Aadhaar judgment. I am entitled to conduct my affairs in private unless she comes and shows that she has a legal right to get added.
Mr.
There was-
Banerjee, kindly consider an order of demolition has been passed
At her
at
instance.
the
I can-
instance of a
that was always-
complainant.
That was always.
So she is not a necessary party. What are you saying?
No, I'm not saying that. But I'm saying that that was the understanding earlier that we would definitely have made her a party. Now, under Article 21, my right to privacy is guaranteed. If there are private proceedings going on between me and the authority concerned, which have resulted in
It's
order of
not a
demolition,
private proceeding. At the instance of a complainant.
she has made a complaint.
Yes. So she has made a complaint, and on the basis of that, an order has been passed. And you can file an application under 218(3) without making her a party.
I mean, I will not be arguing that much. I will not be arguing.
Please serve a copy.
I'll serve her a copy.
My lord, I am also seeking formal implement of the complainant, Mr. Bishojit Dey, then in the 227 application. Because, my lord, the process of demolition has been stayed.
As paid for by Mr. Banerjee, learned senior advocate for the petitioner. Leave is granted to the learned advocate on record of the petitioner to add the complainant at whose instance the order of demolition was passed as a party in this civil division application. First up, let such amendment, let such amendment to the cost title of the civil division application be carried out here and now. First up, petitioner is directed to serve a copy of the application, serve a copy of this civil division application upon the learned advocate who has instructions to appear on behalf of the added party. In course of this day, first up, list this matter on when, till when this interim order is there?
18th, my lord.
My lord, it is in operation till March 18th. My lord has been pleased to stay the demolition.
Lord, I will not be there in town. Kindly keep it on the 18th, if your lordship wants. And
18th,
As my lord pleases.
because 18th is the monthly list day.
then kindly extend it for a very short period.
No,
Keep it. Not 17th, I'll not be in town. 17th, I'm not in town, my lord.
13th,
One indulgence, my lord.
13th to 17th is that holy vacation which we have. I have, my lord, added one day this side and one day that side because of
12th,
12th is. 12th not even.
My lord, may I?
Okay.
Halatnama, my lord.
you are appearing for?
Appearing for the.
She's the advocate on record instructing, my lord.
Yes. Not here in the department.
Yes, my lord, in the department in the course of the day.
I am
Another-
deeply obliged, my lord.
Every service filed in court today is taken on record. Yes, next.
Your lordship, in this matter, Mr. Bilodal Bhattacharya, learned senior advocate, is appearing for the opposite party, your lordship. He is right now at circuit bench, your lordship. Kindly keep it day after tomorrow.
My lord, I'm suffering an order on.
Yes, carry on.
They're enjoying
Yes,
an
sir.
order.
My lord,
Also, it was, yes, Mr. Bhattacharya
no,
is here.
no, my lord, I am appearing, my lord. My lord, I was just urging, my lord, if it can be taken up tomorrow or day after, my lord.
Mr.
I have to-
Bhattacharya, they are opposing on the earlier occasion also it was adjourned.
My lord, earlier occasion, my lord, I had,
At your instance, you mentioned this matter. There was an order.
no, my lord, on the last occasion, my lord, learned advocate on record was not there, my lord. So I was there. There was a difficulty, my lord.
So,
I am, my
Bhattacharya,
lord, I am humbly requesting.
Arguing counsel
No,
will
no,
be
my
there
lord, my lord,
and
kindly, my lord,
accommodation
kindly,
of the
kindly sit up tomorrow. My lord. It's a very interesting point, my lord. I would like to, my lord, really come down and argue the matter.
an accommodation has been prayed for by the learned senior counsel appearing for the opposite party. First up, list this matter on 19th of March under the same heading.
Great.
Yes, next.
90.
Grateful to you, lordship.
Your lordship, kindly put it to 20.
Lordship, I appear for the petitioner.
Yes.
Lordship, this matter was mentioned before your lordship because my son's birthday is tomorrow. Lordship remembers, Mr. Probal,
opposite party.
Yes.
this is my affidavit of service. Lordship, this is in a suit for restitution of conjugal rights filed by the petitioner. The petitioner had prayed for visitation of his two minor sons. One son is now 7 years old and my other son will be turning 6 years old tomorrow, Lordship. The impugned order dated 26/2024, Lordship. With this order, I have been directed or permitted visitation only on the first Wednesday of every month from 4 p.m. to 5 p.m. at the DLSA, Lordship.
Yes.
That is the order impugned which has been passed, Lordship, for today, Lordship. Tomorrow, my son's birthday. If your Lordship is
Yes, Mr.
Kindly-
Chatterjee.
I'm also father, my lord.
What is your submission?
So far as the birthday is concerned, I have no instruction, no knowledge. So apart from birthday, I can say, my lord, being the mother, my lord, and my only appeal of my is only the two child, my lord, two children, my lord.
No, that that may be taken up.
Honor.
Is only tomorrow is the birthday of the child, so the father wants. Yes, Mr. Mukherjee, you are.
Only for tomorrow, my lord, for the time being, I'm not disturbing your lordship with the merit of the matter. But I'll beseech my learned friend, my lord, at least to concede, my lord, that the
Mr.
father.
Mukherjee, where?
Lord, we have, Lord, we have proposed, Lord, we place called the backyard near Science City. Lord, this is a children's place. They can enjoy Lord there. If I can have him from Lord 1 p.m. till Lord 9 p.m. or 8 p.m.
1 p.m. I do not know the school hours. That cannot be.
Huh? School is closed. I'm told the school is closed.
I have no instruction, my lord.
Take instructions because
Can I come
their
at
instruction is
4 p.m. Can I come at 4 p.m. my lord with instruction?
But
Mr. Mukherjee will be enjoying the performing the birthday in the evening because 1 p.m. it's very hot outside now.
but I understand.
Because-
But I talk with my client. He is present.
So evening I think will be
About 6 o'clock or 5 o'clock or something like that.
Closed at 8 o'clock.
It gets closed at 8 o'clock.
8 o'clock.
And it's an indoor area also. So even if it's 1 p.m., it's an indoor area.
So I'm told Lord that it is an indoor area. Lord. Even if it is 1 p.m.
indoor area will be once he or she gets inside. Traveling at 1 p.m.
That your lordship may pick the time.
evening
I
because
leave it to your lord.
from 4 p.m. to 5 p.m. So it can be from
6 to 8.
Lord,
let
maybe
it
from,
be 5 p.m.
5 to at least Lord 9 o'clock. Lord, the order of the learned judges, Lord, that only on the Wednesdays once a week, 1 hour.
That is happening or not happening.
But it is sometimes happening, sometimes not happening. So that is the subject matter of Lord, the challenge before you, Lord.
Mr. Mukherjee, what instructions you have, even if it is allowed, you will be able, the child will stay with you for these 4 hours,
But that is
4 or 5 hours.
at least we will try, my Lord. At least the father wants
So
to
if,
have some.
if it has not taken place, happened prior to this, it's very difficult on that. That is why, what is your instructions
It has
for
previously
this
happened.
4 5 hours?
My instruction, my lord, so far as the child is concerned, my lord,
They are fine with the Lord.
maybe-
Children are fine with the father.
I have just the opposite instruction. Not fine. So that is up to my instruction, my lord.
No, what is that is the children's play area.
Yes.
So there is also some food mart or something like, otherwise,
There's a cafe also, and it's an indoor area, play area.
It's a play area, I'm told.
there's
Lord,
a-
with food and all this.
so the children will only play with the child
No, no,
on the
Lord,
birthday.
no, the food is there also.
Food is-
Food is available.
We can arrange a birthday party there.
Mr. Chatterjee, you take instructions from your client. So tomorrow from 5 to 8, the mother will also accompany.
Certainly. my lord.
Mr. Mukherjee, ask your client also to offer something to the mother. And the, so I think the others, your other son or daughter, there are 2 sons.
Let him also come. Let him also
So
come.
he will also come. So
Mother will also.
don't restrict your cafeteria to the,
Lord,
only to the son who is,
the sons are Lord, they are very comfortable with the father. But it is up to
take
20,
instructions
20,
from
they are
5
living
to
with
8. Till 8, it's open, play area.
It is open.
Yeah, it's open.
Open.
And where is the child staying? Because they have to again go back.
Lake Town.
Lake Town.
Lake Town area. So it is
Mr.
Lord, this backyard is near Science City.
Mr. Mukherjee, do it within 7 because they have to return to Lake Town.
Then Lord, your lordship will give it Lord from
4 to
4 to
7.
3 or something like that.
4 to 3 hours is enough
4 to
to
7.
to celebrate birthday.
Lordship. As your lordship pleases. Lord, I'll not.
Mr. Chatterjee, take instructions. There is no 3:30 today.
No.
So come at 3:15.
Lordship. Lord, this lady will be there. Lord.
You will be in difficulty.
I'll be having difficulty, but Lord, it is
4
under.
p.m. 4 p.m.
Lord,
So if he comes with some other instructions,
Lord,
at what time will suit you?
Lord, I may not be available.
After?
Lord, I have to leave the court.
Just now.
Lord, I'm sorry, Lord, I cannot assist your lordship. But Lord, now that I understand, Lord, it is only about the time.
2:45.
আরে আমাকে বেরিয়ে যেতে হবে আমার 3টের সময় একটা appointment আছে
All right. So from 4 to 7, take instructions. The mother will also remain there, but she will not create any obstruction. But the other son will
be
also accompany.
Provided if she finds anything, if the mother finds anything not suitable for the child, he may react. I don't know what will be the situation there.
At least on a son's birthday, we expect the parents
What
to
reacting?
behave blood responsive.
What
I mean,
reacting?
there's no apprehension about that the mother will be blood reacting.
Mother will be
No,
there.
because there's a,
but-
my instruction, there's a earlier occasion, they try to abduct the child from the school.
There's no question about that. But when
Mr.
blood, we have
Mukherjee,
to
that
put a-
is, that is
But
the
that is-
allegation.
that is
that
not
was
an
the
allegation from the birth. If it was the case, blood, if the child would have been in my custody as of today. Blood, allegations can be anything wild.
Take instructions, come at 3:15. Yes, call the next matter.
33.
Yes.
On behalf of the petitioner, my lord, this is from.
Plaintiff opposite party, my lord. Although no caveat is lost, plaintiff opposite party.
I think this can be mutually settled. My lord, my application for my lord examination of a witness on commission is rejected. My learned friend my lord never my lord objected to that. My lord, I tell you, lordship, my lord, what is the suit about? Definitely, my lord, my learned friend is asking for a copy. My lord, I will immediately make over a copy to him.
Kindly have to fix it to tomorrow.
What is the date fixed?
Tomorrow your lordship kindly to fix it.
What is the next date fixed?
That's my lord later. My lord, if it is taken up tomorrow, no difficulty. My lord, I have
Give him a copy because
18th of March, my lord, is that.
18th of March. So I am keeping
For
it on
argument, so my lord, I want my exam, witness to be examined in the meantime.
13th. When this matter is taken up for
My lord, I am appearing on behalf of the petition.
yes.
My lord, the petition, the opposite party, tenant has filed, instituted the suit against the petitioner landlord for declaration his tenancy, my lord. My lord, this suit property is situated at the Panchayat area, but he has filed the suit under the West Bengal Premises Tenancy Act. Well, kindly see the plaint, paragraph 9 of the plaint, page 16.
Give me a minute.
Element about what is
Where is your application?
My lord.
Where is the plaint?
My lord, kindly trouble to turn page 16, paragraph 9. His plaint, my lord. That the plaintiff respectfully submit that he is a monthly tenant under the West Bengal Premises Tenancy Act and cannot evict forcefully and illegally. And as such, the plaintiff has no alternative but to file the instant suit, praying for necessary declaration and injunction. And Mali, if you kindly trouble to turn the page 16, the prayer portion, the plaintiff respondent pray. Well, got it, Mali?
Yes.
Decree for declaration that the plaintiff being the tenant under the West Bengal Premises Tenancy Act cannot be evicted without the due process of law. Decree that the plaintiff is entitled to enjoy the tenancy without disturbance or obstruction in any manner and removal of obstruction mentioned forthwith.
Where is the application under Order 6 Rule 17?
My lord, they have filed, subsequently, we have filed the Order 7 Rule 11, my lord. Subsequently, this plaint, we have filed the Order 7 Rule 11 application and the same order has been rejected.
We have filed an application under Order 6 Rule 17.
They subsequently have filed the Order 6 Rule 17, my lord.
Yes. What is the amendment sought for?
Sought for no, Order 7 Rule 11. No. Page 32, 30, no, no. But the application under order 6 rule 7 is page 27 annexed D.
I beg to appear, on behalf of the petition. My lord, need not take the records. My lord, I just give your lordship, the bird's eye view of the matter. This is from, my lord, an order passed by DR80. My lord, need not look at the records as of now. My lord, there was a SARFAESI proceeding initiated against me. My lord, I filed, my lord, a section.
You are the borrower.
I'm the borrower. My lord, I filed a section 17 application challenging a sale notice. My lord, while the section 17 application was pending, my lord, there was a subsequent sale notice. So, my lord, I filed an interim application. My lord, the interim application and also, my lord, the main application was dismissed, my lord, by DRT, my lord, Debts Recovery Tribunal, my lord, on the ground.
Main application means section 17.
All. Lock, stock, barrel together. My lord, saying that my section 17 application is out of time. Akshat commercial and all, my lord, committed a wrong, my lord, that's a different issue of the matter. I'm not troubling your lordship
Challenge
with
before
that.
DRT.
DRT. Now, my lord, before DRT, my lord, I need to put in, my lord, a pre-deposit. Well, that's the condition precedent, my lord, for filing a statutory appeal under section 18. Now, what they did, my lord, the bank, my lord, sold my property. Got, my lord, much in excess of what was due. My lord, I was having a cash credit, my lord, account. I was also having a savings bank account. What, my lord, the bank mischievously did, my lord, I use this expression, my lord, consciously. My lord, the surplusage amount, my lord, after sale and after, my lord, giving credit to, my lord, everything, after zeroizing the loan account, the surplusage amount was credited, my lord, to the cash credit account. So, my lord, it gives birth to a loan again. My lord, that amount should have gone to my savings account because it's my money. Property is sold, excess money, bank refunds. Bank should have refunded it to my savings account. Bank opens a cash credit account. My lord, gives it there. And then, my lord, from the cash
Treating it to be a loan.
Again, my lord, out of the blue. And my lord, from that new loan account, my lord, number remains the same, account number remains the same. After zeroization of the loan accounts, my lord, is again reopened. Now, my lord, from that loan account, what bank has, my lord, debited or recovered is, my lord, recovery agent charges. Unheard of. Recovery agent charges, litigation cost, my lord, interest. And also, my lord, what bank did after that, bank introduced my mother into the, my lord, loan account. My mother had got nothing to do with the cash credit account. Mother was having, my lord, a gold loan account, my lord, separately. My lord, mother was introduced without there being, my lord, any application. It was a single account, made a joint account, bank, out of its own. Now, my lord, the gold loan amount was also started getting recovered from, my lord, this cash credit account, which was not even a subject matter of the SARFAESI proceeding. So, my lord, I approached DR80. My lord, I told DR80 that, my lord, had this amount been not recovered, my lord, I would have deposited this amount. So, my lord, section 18 deposit does not come here because my money has been taken away by the bank. DR80 was with me. My lord, repeated order passed. Even the general manager of the bank was called upon for personal appearance. Then, my lord, I do not know what went wrong. Ultimately, by passing the impugned order, DR80 says you deposit the money.
Lordship,
You are
I'm
appealing for the bank.
I'm for the bank. Lordship, may I be served with a copy, and I'm being led by Mr. Nimesh Mishra in this matter. Lordship, may this matter be
And
kept
this similar operation of the order,
Lordship, may I
my lord, will
please
come back.
serve with a copy, Lordship.
What is going to happen, Mr. Banerjee?
Now, my lord, if I do not put in the pre-deposit, my appeal will be dismissed.
What is the date?
My appeal has been dismissed. I filed a recalling application. The recalling application is pending.
When it is to come?
Copy? 12th. My lord,
12th.
Kindly stay all further proceedings. Let us, my lord, thrash it out, my lord, here. Will, my lord.
Stay of all further proceedings with Mr. Banerjee.
DRT.
The DRT, your DRT proceedings has been dismissed.
Now,
Appeal
stay
has
of the
been
recalling application.
So recalling application is your, if it is stayed, recalling will not be hard.
No, correct. My lord, I suffer the loss. But today, if I, my lord, succeed before my lord's court, my lord, enter thing goes. My lord, I'll take that risk.
So only the further
all further proceedings.
Hearing of the recalling application only.
Kindly say all further proceedings in connection.
What is the other proceeding?
That's the only application.
So
that's not.
Lordship, before your Lordship passes
Milord,
the
I have
order, I'm
stated
just
so.
requesting
Milord,
your
in-
Lordship to keep this matter tomorrow. I'm being
But they are
led by
not
Mr.
unclear yet.
Mishra.
Milord, page
Lordship,
16,
there
paragraph
were
70.
several factors which has to be brought on record, Lordship.
12th is the
12th
date.
is the day.
Mr. Banerjee, sir, for a copy. I'm fixing on 12th.
এক্ষুনি দাও।
আসুন। when this matter is taken up for hearing.
Grateful, my lord.
36.
In item number 36, I am for the petition. My application under order 6 rule had been,
Your application under?
order 6 rule 17
Yes, has been
rejected, my lord. Well, kindly have a look, my lord, last page, my lord.
preemption application.
Preemption under it.
Yes, what is the
Exactly.
application which you have sought for?
Well, on the ground of vicinage, adjoining landowner, I have filed order 6.
Adjoining landowner you want to incorporate.
I have filed that I am adjoining landowners by way of inheritance. Subsequently, it has been found that one settlement deed has been executed and registered in my favor, in our favor. That has been searched out, and I want to incorporate that in the Section 8 application by way of order, amendment. That has been rejected. Well, in the similarly situated matter, my lord, same court has been pleased to allow that application in another case. Parties are same.
Maybe, but what stage? Argument stage?
No, my lord.
Yes. Kindly come to
Yes,
the order.
Argument stage.
Where?
Well, kindly have a look my application. That was misplaced. I have stated already my application.
That
page
may
number
have
30.
been.
Well, subject to payment of cost, my lord. In another application, my lord, that
What
has been
happened?
allowed.
What happened? What was the date fixed for argument?
11th. This 11th.
10th of January, what happened?
Well, adjournment has been sought for. Adjournment was granted. Next date has been paid on 11th, my lord.
Where is your application?
Well, kindly see page number 32. Written in Bengali, my lord. My lord, second paragraph. সালিসি সম্পত্তির অ্যাডজয়নিং প্লটগুলিতে অধীনগণ উত্তরাধিকার সূত্রে প্রাপ্ত হইয়াছিল বলিয়া দাবি করিয়াছিলাম। প্রকৃতপক্ষে উক্ত দাগগুলিতে অধীনগণের পূর্বাধিকারী গোপালচন্দ্র বর গত ইংরেজি ১৬০০ তারিখে সম্পাদিত ও ১৬০০ নম্বর রেজিস্ট্রিকৃত নিরূপণ পত্র that has to be incorporated. It will not change the nature and character of the main application, my lord, and my opposite party will not be prejudiced in any way.
Where is your application under order 6/17?
Page number 32, annexure D. Second paragraph, my lord. Written in Bengali, my lord.
Where is the explanation for the delay?
My lord, that was misplaced. I have stated, my lord. In second paragraph, my lord. And my lord, proposed amendment, my lord, in schedule, page 34.
Where is your original application under section 8 and 9?
My lord, page number 19, my lord. Annexure A. Paragraph 6.
Give me a minute. What is your name?
I am my lord Subhash Chandra Bor Shuktipada Bor. Paragraph 6 and 7 of my application. Principal application. Page number 34 of the schedule proposed amendment, schedule of proposed amendment.
Ashwin. By the order
37.
37, I appear on behalf of the petitioner, my lord. My lord, by the time the order was passed and we tried to communicate, my lord, the petitioner was dispossessed. So, my lord, we could
You have
not.
to take steps.
Yes. So, my lord, kindly, my lord, passes order and disposes of this revisional application. My lord, only one thing, my lord, we have tried to serve, my lord. Till today, the service has not been affected.
It has been submitted by the
My lord, I'm for the opposite party, my lord.
This is my application, my lord. The last
Yes.
question, my lord. This is an application, my lord. We are asking for quality of the order passed by the learned trial court, my lord, for examination of the PW1, my lord.
Lordship recalls 86-year-old man suffering from Parkinson's. Lordship
You
had
have told it to
directed.
Mr. Bhattacharya.
I have seen, my lord, these documents does not bear the signature of the patient first. The
Mr.
second, my lord.
If I
If you
put
not-
my
kindly-
signature
kindly,
amongst-
kindly, my lord, kindly seize, my lord, kindly seize the document, my lord.
Yes, Lordship.
The document, down.
This is the one that I have annexed with my application under Order 26.
Mr. Bhattacharya, if you say so, I will give her a liberty to file a fresh certificate that Mr. Bhattacharya, unless instead of that, if I direct the commission to be concluded within a certain time.
No, only I am saying, my lord, this is, my lord, this application itself, my lord, I should say, my lord, in view of the, my lord, the order passed by the trial court, my lord, there is no, my lord, satisfaction of the court that he is suffering from certain ailments. My lord, kindly see, there is no signature.
All right, so I will
Put my
direct.
signature, my lord, it amounts
What
to
I am
tampering with a certificate. How can I put my signature?
No. He says that the certificate ought to have, the signature of the patient ought to have been there.
And not a single prescription has been given to your lordship, my lord, from
Lordship.
which your lordship can ascertain that he is suffering from, and also there says, my lord, mild Parkinson's. My lord, not a single prescription
How many
provided by my
more?
lord to this court, not before the trial court, not to this court also, my lord.
Mr. Bhattacharya, if you
My lord,
say
can
so,
you remand it back, my lord, to trial, my lord, so that I can examine, my lord. I need to examine the witness.
where are those prescriptions? You have not brought those. Show it to Mr. Bhattacharya.
I showed it to him.
My lord, kindly see, no prescription is there, not a single prescription.
There is one.
Yes, these prescriptions are there.
My lord, only one
Lordship.
prescription is 2025.
Do I have to
thing, my lord,
produce
there
all
is
the
no-
prescriptions,
1st
my
of
lord?
February 2025.
Yes,
That
Lordship.
is the
latest.
prescription, my lord. Where
That
is
is
if
the
a person
latest
is suffering from
prescription.
Parkinson's from long, my lord, their whole prescription must be there. My lord, can you want
The direction was Lordship to produce a prescription. If Lordship so directs that to produce all the prescriptions, I will bring them, my
My
lord.
lord, kindly
All right, I am directing the.
Well, trial could be hardly deference, my lord, subject to, my lord, give a chance to cross-examine the witness.
What cross-examine?
Well, the doctor need to be examined, my lord.
No,
Can
that
you
is
see
not
the
required
document
under
provided
the
by the doctor?
explanation, Lordship,
Kindly
of
see,
Order
kindly see, my
26.
lord,
It has been
there is no
stated.
signature of the doctor also, my lord.
There's
In a prescription.
There is a signature.
doctor's
What is
signature
he
does not-
submitting? There's a signature of the doctor with a stamp.
So, Bhattacharya, kindly see this.
My lord,
It's a doctor's.
my lord, I'm showing to you.
The certificate of the doctor.
I'm showing to you, my lord. Kindly see, my lord. This letter 1st February 2025. There is
Trying
no,
to call up an 86-year-old man.
When this order was passed.
my lord, this order was passed, my lord, on 16th December.
Yes, 16 December. So, where are the prior certificates?
Lordship directs I will produce all the prior
My lord, there is no
certificates.
signature. Kindly see, my lord. This prescription does not bear a signature.
That is only an advice, not a prescription. The tests that have been
No
directed
medicine.
to be
What
performed.
medicine has been given?
Medicine is there.
My lord, kindly see,
Lordship.
what a medicine, my lord.
Medicine is there.
Yes, my lord, I'm telling also PAN 40, then Neurobian 4, P65. A person suffering from, my lord, Parkinson. These are the medicines. I put this question to myself. My lord, this person does not bear the signature of the doctor. Can you see what document producing before this court, my lord? This prescription does not
So
bear
this
the,
is with regard to those some.
no medicine has been
No,
prescribed in 20.
some tests were directed to be conducted.
But not by the signature of doctor, my lord.
I have never been seen by a prescription prescribed by the doctor without his signature, my lord. And this signature also, there is no rubber stamp.
By the order impugned. No, by the
My lord,
Yes. 39. 39
39. Lordship, appearing on behalf of the defendant petitioner, this is an ejectment suit. So on the last occasion, I have, as you have cited about the 3 judgments, Devashish Paul versus HON'BLE
You have seen,
I have
seen these
gone,
arguments.
yes.
Yes. Now what is your submission?
Now I'll keep the arguments very short. I'll not make any irrational submissions. Okay. The thing is that if I make a chronological recapitulation of the judgments,
is section 5 maintainable in 717?
I'll just come to that. I'll just come to that. Okay. Just consider my case. Just hear me out for 2 minutes. Okay. In case of Nasiruddin versus Sitaram, it was told the court clarified that the rent control laws protect both the landlords and the tenants. Okay. And then coming to Amit Kumar Chamaria, the courts again clarified that any violation of statutory timelines would result in eviction based on the principle that was established in Nasiruddin. Now, in Devashish Paul also, the Supreme Court ruled that Section 5 of the Limitation Act does not apply. But, Your Lordship, I'm aware of the Devashish Paul judgment, but those cases actually dealt with the tenants who failed to comply without valid reasons. And unlike Devashish Paul, where delay was due to negligence, my client actually faced a genuine crisis, a family member's terminal illness. Now,
if section 5 is not maintainable, those merits cannot be looked into.
But Devashish Paul's ruling does not outright ban condonation. It only reiterates.
Yes. Section 5 is not maintainable. It has been held in section 7(1). Section 5 is not maintainable because the section does not contemplate filing of any application. 7(2) also, section 5 is not maintainable.
Right, but if your lordship considers that the delays should not be routinely excused, okay, and I agree to that. But in exceptional cases, equity must.
I gave you a chance since that was the first maiden appearance.
I agree, but at least if you let us have notice on the other side, I'll not argue.
The maiden appearance, for that I adjourned. I've posted another day.
I'm pretty aware of that.
And Mr. Rokit is sitting by the side. Yes.
Obliged, Lordship.
Yes.
For giving present sharing.
Has to be.
Yes.
That is the reason why on the last occasion I gave him a chance.
My lord, this is my application, my lord,
I'm
against an order, my lord, under which a section 47 application has been dismissed by the, my lord, commercial court at Alipur. My lord, in an execution proceeding under section 36. Now, my lord, there are 2 applications, my lord, 40 and 41. 40, my
How
lord,
much time it will take?
it will take some time, but there is extreme urgency because they have, my lord, now, I believe, my lord, filed certain documents and are pressing, my lord, the attachment of a property, which of course does not belong to me, and an account,
which belongs to me, which is a salary account.
What is the next date fixed in the?
Today it was somehow, my lord, we have given, my lord, but then he says that
What is the
we had
next date?
sought for an adjournment. They did not give an adjournment today.
Sir, when
It has not yet been fixed.
No, but then he's not giving adjournment. I cannot, my lord.
So, my lord kindly appreciates, my lord, adjournment doesn't come as a matter of right.
Absolutely, absolutely.
On the last
That is
occasion
why I'm
when
saying kindly takes up the
Excellent.
matter, my lord.
On the last occasion when the
two
matter
matters, one is fixed at
May it be on
3:15.
Thursday, my lord. I had a word with Mr. Roy. Thursday, if we can do it, my lord.
Thursday.
Yes, my lord.
All right.
Both the matters, my lord. 40 and 41.
That is why, my lord, yes, now Thursday was only one matter. That matter.
Now, my lord, he took a
order
point,
was
my lord,
made.
that
And Mr. Banerjee's junior was apprehensive that this matter will not be reached today.
I
he was
was,
rushing at
I
2
was
PM.
told, I ran from NCLT. I was told, I said, no, my lord will reach. I know that. My lord will reach it.
It has been on the joint prayer of the motions, first time motions has to be given preference.
Only difficulty is that, my lord, I said, my lord, unless, my lord, he is not agreeable.
What?
What am I agreeable?
The Alipur court.
Because it's a commercial suit.
Yes. No, I don't blame the court also. I want to do it before, my lord.
Yes. Next. Call the 315.
Grateful, my lord.
My lord, I'm not going to the merit of the matter, but my lord, if my lord kindly consider the second page of the judgment, the
Second page of the judgment, yes.
by filing the written objection. Impugned order, my lord.
Yes, second page, which portion?
By filing the written objection, the respondent mother denied.
That is third page, yes, by filing the written objection.
I stand corrected, my lord.
Yes,
My
yes.
lord, if that be so, my lord, the instruction which I received from my client is that, my lord, whenever a person to this order, whenever the child is given to the father, my lord, the allegation is that father has provoked the child in such a manner, my lord, that it has already gone through mental shock, and for fortnight, my lord, it takes time to restore the child. And in fact, in the school also, my lord, a counseling is going on for this purpose. Even, my lord, the school authority has told, my lord, that the child is found unconscious.
Lordship, these kind of allegations, Lordship, this will come and keep coming. Lordship, this is in the merit of the matter that may be kept aside. The mother will be accompanying. We have no objection to that. The father, the parties were residing together.
You have not challenged this order.
My lord.
So the father was allowed visitation for some time at some place.
Lordship, the father.
So you have not challenged that order. So for that date, 2-3 hours, you will also be present.
Yes, mother be present. Lordship, this is a suit for restitution. The parties have separated only in November 2023. They were all along residing together in the same mess.
Ashwin.
Lordship, kindly restrains the mother's presence only because my instruction is that the parents-in-law of the petitioner might also accompany. That might aggravate the suit. Mother be present.
Strategy asked the parents-in-law not to accompany. Otherwise, there will be some problem.
She's a female person. At least the brother may accompany the mother.
Then I will appoint a special officer.
My lordship will kindly. Lordship,
kindly, my lord.
Kindly appoint somebody.
In the presence of a special officer. Okay.
That is also good for the
What, the special officer?
Special
Why?
something court.
Why? The officer will be in colored dress. There will be no difficulty. Why? What is the harm?
I have no issue.
Lordship, anybody, Lordship suggests anybody of Lordship's preference tomorrow, but tomorrow is a fourth day. So that is the difficulty.
Tomorrow,
Lordship, the children, my instruction is that children are very comfortable with the father, and that is what is scaring the mother possibly.
the honorary advocate on record of both the sides will be present as joint special officers. I think that will be better.
Lordship,
So both of you can take care of that.
then that has to be after.
So the time, everything will be according to your convenience. Clients will also agree to that.
Lordship, my advocate on record possibly is
Advocate on record is,
my junior, who is today not.
if you want, you can be allowed to be present.
My junior is also the advocate record, and he's in Bakura at present.
You can,
If my lord, otherwise, London brother can be.
Who?
Lucky bhai.
Tomorrow at what time?
9%.
Near Science City. At what time? Tomorrow.
5:30
ওটা 8টা অবধি খোলা থাকে বাবা, একদম টাইম পাবে না তাহলে।
আমার কিছু করার নেই, আমি
বাবা will add in
4:30.
4:30 will be difficult, man.
5.
Well, 5:30 will be convenient, man.
The
Very
child has to be, after that, the child has to be taken to Lake Town. You cannot make by 5.
That's 5.
The সিরিয়াল না একটা ফিক্সড আছে না সেটা ডাকুন ইয়েস
মানে 40
একটু আগে করে দেবেন এটা একটু আগে করে দেবেন ইয়েস
But just to remind your lordship, my lord, on the last day, that I have almost placed the facts, my lord, the commercial suit with regard to the publication of books, my lord, the plaintiff and the principal defendant number 1 is fighting. The defendant number 2, my lord, I handed over a small, my lord, list of dates before your lordship.
Yes.
From the list of dates, it will be appearing, Lord, that the defendant number 2 initially filed his written statement along with the application under Section 5 of the Limitation Act. Those was not taken on record, Lord. That, Lord, Section 5 application was not till date disposed of. In the meantime, unfortunately, Lord, the defendant number 2 died. In his place, Lord, his heirs are being substituted, defendant number 2A to 2C. Now, Lord, so far as regards 2B and 2C is concerned, I have shown in my list of dates when they appeared. Initially, they took out an application for, Lord, adopting the written statement filed by the original defendant. That is the course of law, Lord, according to me.
Thereafter, they did not press that application.
They withdrew that. They filed an written statement in a disguised form of an additional written statement unknown to the law. That was also belated. No application under Section 5 appended to that. And the statutory period of limitation as not prescribed under the Commercial Courts Act, which is mandatory, that has been lapsed. So at that juncture, he disappeared for one year almost. That has been recorded in the order impute. Thereafter, he took out the cyclostyle application that I have shown before your lordship, that 3 or 4 paragraph application, nothing is being disclosed over there. That has been allowed by the order impute in one breath, and the second breath, the learned judge is allowing that substituted defendant to participate even on the interlocutory proceeding. So this is my twofold grievance before your lordship. If I might just kindly takes up the application type of volume 3. Kindly takes up volume 3, the application once, and the impugned order, and thereafter, I shall place. And I must point out, one point cropped up in your lordship's mind, that the counterclaim which, because your lordship is of the view why you are aggrieved, being one of the co-defendant in the suit. I said that I do have my independent counterclaim appended to my written statement. And after seeing the prayers of that counterclaim, your lordship is of the opinion that it is not touching to the plaintiff alone, but also touching to some of the co-defendant, whether I can maintain that. That the query of your lordships on the last day, I shall answer that also. 182. Page 182, if your lordship wants.
182.
Yes.
Yes.
Kindly looks at what is the application. This is the focus which was initially not filed, and page 186 is the recalling of ex parte. Same, almost same paragraphs. Any of the application your lordship takes up, I say, since it's a commercial suit, there are rigors additional to that regular suit under Section 9 of the Code of Civil Procedure. As like the Honorable Supreme Court has mentioned, that initial period of filing written statement in case of original suit is 90 days, but here it's 30. Even after 30, he has to give explanation why beyond 30, and thereafter 90 is a yardstick. After 120 days, nothing can be done, but not in like general suit. So, he must be more cautious to give explaining something that he was not there for 1 year in a commercial court, recorded in the order impugned, but this is the explanation which has been given. Whether this can be worthy of consideration, and how the learned judge has dealt with, kindly now looks at the order impugned before your lordship. Order number 71.
Yes. Order number
71, dated 6th of February 2025.
Yes.
I have placed below only below first page, last paragraph. May I place below this? From the instant record, hurriedly below I shall place this. From the instant record, it appears that the defendant number 2B and 2C appeared before this court and preferred application IA such and such for adopting the already filed written statement of the original defendant number 2 hearing. However, the said written statement till then was not accepted in record of this instant suit by this court. As the said written statement was pending for acceptance along with an application for delay condonation petition for acceptance of the same, subsequently on such and such, the petitioner hearing had filed their additional written statement which was kept on record. It further reveals from the record that Miley marks this 13th of September 2023 till 13th of August 2024 in Seritin, for nearly 1 year, the defendant number 2B and 2C herein had refrained themselves without any cogent reason for appearing before this court in the instant suit. As a sequel, on such and such, this court fixed the instant matter on ex parte board against the said defendant after providing opportunity of show cause video order dated such and such. This show cause was not given. Now, my lord, I am skipping that. If your lordship takes up the third paragraph of that page, considering the aforesaid, has your lordship got it?
Yes.
And also the perusal of the materials of record, it appears to me that the objection raised by the defendant number 2A should be subject matter of the full-fledged trial. Therefore, that aspect could not restrain the defendant number 2B and 2C from entering into the instant suit. More so, on considering the reasons as stated in the instant application, this court hereby allows the prayer delineated in the instant application for the ends of justice. And now, in a cyclostyle manner, I filed my written objection, being the defendant number 1, to their application for ex parte vacating, extensively taken all those points, not even dealt with by the learned judge. This is my submission. This cannot be in a routine manner in a commercial suit. In a 3-paragraph application, this cannot be a judicial order in my respectful submission. Now, kindly takes up the second point of mine. Kindly last paragraph of that second page. One application filed by defendant number 1 on such and such with a prayer for IA such and such along with IA. These are the two successive injunction application. After directing the parties, my lord, kindly marks this portion. In this suit to file their respective written notes of argument in IA 13 of 2021, which is lying on the docket of the record, let this application be registered as IA such and such, 26. This, my lord, 20, thereafter the parties are directed, my lord, if I just skip the fixed matter, thereafter parties are directed to file their respective written notes of argument to the application of IA such and such, if any, and also file objection to the application of IA 26 of 2025, if any, in the meantime, after exchanging the same to one another. So, my lord, if this is something, my lord, the learned judge is proceeding without even deciding that 2B and 2C, whether defense of that defendant is still there or not. It's admittedly, my lord, on record, it's not there. If that be so, my lord, as per my lord, the judgment of the Honorable Supreme Court in Modula India and be followed up to date, he has only the opportunity to participate in the cross-examination, or that too, my lord, based on the claim of the plaintiff as my lord couched in the plaint, and to participate in the argument.
So the additional written statement has been accepted.
No, it's on record. I say, my lord, that written statement, additional written statement, is also beyond my lord time.
That has not been accepted.
Not been accepted. So all these previous, my lord, matters ought to have been dealt with by the learned judge. As if the learned judge is, my lord, I know, Order 9, Rule 7. It is like putting the defendant back to the same position as it was there, my lord, prior to, my lord, fixing it ex parte. So it is giving him an opportunity to put back to a situation which was there 1 year before. But it's not that 1 year before his defense was alive. Because he has to take whatever responsibility or whatever the duties that has been done by the father. What his father done? Yes, he has filed a written statement belated along with Section 5. He chooses to file an application for adoption, but ultimately that has been not pressed as per his own choice. So what is the law? What is the position that defendant do have without ascertaining the learned judge on the same breath is allowing him to even participate in the interlocutory proceeding? That in my respectful submission is not there, my lord. But your lordship knows, my lord, only for the purpose of আমার একটা না ওসি বলে লেখা আছে আমারটা আমাকে দাও আমারটা দাও May I just? Lord, it's AIR 8, 1989 Supreme Court, page 162. Lord, your Lordship knows, Lord, the position of law.
Paragraph.
Lord, it's. Lord, kindly takes up page 175. It's not. Lord, paragraph are not.
Yes.
Yes.
Lord,
It's the
175.
continuation of paragraph number. But it's a long.
Yes, yes, 175. Which paragraph?
Lord, last paragraph. Right-hand side.
column.
Yes. We therefore think that the defendant should be allowed his right to cross examination and the argument. But we are equally clear that the right should be subject to certain important safeguards. The first of these is that the defendant cannot allow to lead his own evidence. None of the observation and decision cited have gone to the extent of suggesting that in spite of the fact that the defense has been struck off, the defendant can adduce evidence for his own or try to substantiate his own case. Secondly, there is force in the apprehension that if one permits cross-examination of the plaintiff's witness by the defendant whose defense is struck off, procedural chaos may result unless great care is exercised, and it may be very difficult to keep the cross-examination within the limits of the principle discussed earlier. Under the guise of cross-examination and purported demolition of the plaintiff's case, the defendant may attempt to put forward pleas of his own to perceive the difference between the question put out to elicit a reply from the plaintiff, which may derogate from his own case, and question put out to to substantiate pleas in defense, which the defendant may have in mind, and to restrict the cross-examination to its limits will be not easy task. We think, however, that this is a difficulty of procedure rather than substance, as pointed out by such and such. Now, the third safeguard which we like to impose is based on the observation of this court in such and such, as pointed out there in the essence of the matter, is in all such cases, it is the latitude that may be extended by a court to the defendant in spite of his not having filed a written statement should not cause prejudice to the plaintiff. Where the defendant does not file a written statement or where he chooses not to appear to contest the case, the plaintiff proceeds on the basis that there is no real opposition and contents himself by letting in just enough evidence to establish a prima facie case. Therefore, the court should ensure that the permitting the defendant in a later stage either to cross-examination of the witness or participate in the proceeding in the plaintiff in not taken by surprise or gravely prejudice. The difficulty, however, can be is easily overcome in practice because there is a wide discretion in the court, and it is always open to the court where it believes that the plaintiff has been misled or exercised its discretion in shut out cross-examination or to regulate in such manner as to avoid any real prejudice to the interest of the plaintiff. Now, the objection I'm just skipping. Your Lordship takes up the last page, page 177. Ultimately, my Lord, for the above reasons, my Lord, it has been 177.
Yes.
Only two rights is being provided. So, my Lord, if this is restricted to only with regard to this, the court cannot go into on the same breath allowing the said, my Lord, defendant to participate in interlocutory proceeding. And I say, my Lord, his application even for ex parte vacating.
Yes.
I say, my Lord, even the application for ex parte vacating, which I am not repeating, without any substance, without any explanation, that should also not to be considered, my Lord, by the learned trial judge.
Yes.
So this is my submission with regard to, and my Lord, your Lordship knows, my Lord, Supreme Court. This is also, my Lord, I am just citing for your Lordship's, my Lord, kind perusal, AIR 2019 Supreme Court, 2002. This is also, my Lord, regarding the outer limit, which cannot even, my lord, extend. Paragraph 8, 16 and 18, my lord, I am relying on.
8, 16 and 18.
Yes, my lord, it's on the point that, my lord, it's settled now. Now it's settled, my lord. And, my lord, the last judgment of mine, my lord, regarding the your lordship's, my lord, query, my lord, I have, my lord, found out, my lord, 2006 volume 12 SCC page 734. If your lordship kindly takes up this. Paragraph 21, if your lordship once looks at. The conspectus, my lord, that was of your lordship's query. Has your lordship got it, my lord? Paragraph 21. May I just place, my lord, first portion of that. Normally, a counterclaim, though based on a different cause of action than one put in the suit by the plaintiff, could be made. But it appears to us that the counterclaim has necessarily to be directed against the plaintiff in the suit. Though incidentally or along with it, it may also claim relief against the co-defendant in the suit. But a counterclaim directed solely against the co-defendant cannot be maintained. This is, my lord, only with that respect. So, my lord, it's not an absolute, but I cannot maintain a counterclaim solely against my co-defendant, but it can touch some.
Yes.
So these are my submission, my lord, with regard to.
Yes, Mr. Mukherjee.
And, my lord, just, my lord, your lordship keeps in your lordship's mind, since Mr. Mukherjee had said that why this co-defendant is so much anxious. But I must say, I am agitating a cause of the plaintiff also. So, because it is the plaintiff who's sued, and my counterclaim is being delayed. So, my lord, I must say, my lord, the plaintiff also, my lord, should sail on the same boat, rather than supporting this order.
We will not submit. কি সাবমিট করবেন না কিছু আপনি করে নিন আপনি কি সাপোর্ট করবেন ওকে আপনি করে নিন স্যার আপনাকে বলছি আপনি
He is supporting.
I will submit.
He'll submit.
Whenever this honorable court deems, I will submit on my point. Whenever this honorable court deems, I will submit on my
To submit first because he has to give his reply. If you want to make any submission, you can make submission because Mr. Mukherjee will give you because you are supporting Mr. Mukherjee.
Your Lordship, before going into the impugn order or the application from which the order procured, may I submit one thing? I am one of the substituted defendant in this suit, 2A. That is the elder son of the erstwhile defendant number 2. I entered appeared in 2023. Subsequently, my 2 other siblings also entered appeared in the suit. I filed my written statement, which subsequently got admitted in the record, and no challenge against such written statement is pending anywhere. After the defendant number 2, B and C entered appeared, they initially filed for adaptation of the original WS, but subsequently rendered that and filed their additional written statement without any Section 5 application, which is till date not admitted in the record. Now, if your lordship kindly comes to state in page 182, the applications.
Yes.
Paragraph number 2. Your petitioner, defendant number 2 BC, states that the defendant number such and such are very much diligent in nature, but due to some contingency in fund, the defendant number 2B and 2C could not appear in the said suit till the last date. This is the only explanation of their non-appearance. Two defendant has taken the same stance in the recalling application as well as the show cause vacating applications. Now, if your lordship kindly comes to page 185, that is the page of affidavit.
Yes.
It is just as normal in a regular suit. Now kindly comes to page 184. That is the affidavit of Taposh Devnath, residing at 552/2 Shipur Road. Now, your lordship kindly straight away comes to the reply made by the said defendants. That is at statement of truth now therein as 276 page. The residing address suddenly changed to 55/2 of Taposh Devnath. If I am claiming that I am diligent, this is not a proof of diligency. Now, my submission is that why I am being aggrieved by the order of this.
You have not challenged.
No, but I am also being a party aggrieved. Your lordship kindly sees this affidavit, which has also been filed by the defendants. Kindly state comes to paragraph number 12. 12. Page 4. May I read?
Yes.
I am aware that my brother, namely Shopon Devnath, has made illegal contention against the plaintiff. He is fully conversant that Dev Sahitya Kuti cannot have any right, title, or interest, including copyright, of the literary and artistic work of the late Naran Devnath. I would submit that any contention raised by my brother, namely Shopon Devnath, need not be taken into consideration by this honorable court. Without having my any pleadings, that is written statement in the record, can a defendant make this kind of affidavit? Under which provision? And more so, this is a copyright suit, not of literary and artistic. This is a copyright suit exclusively dealing publication and selling right between the defendant number 1 and the plaintiff herein. Now, while granting the order of recalling, there has been certain criteria which needs to be considered by the learned court for recalling of a vacating order, whether past and foremost criteria is that whether the vacating affect the party which is reparable or irreparable loss. In this case, my humble submission is it is neither a loss in nature of irreparable nor in reparable. There is no loss because the original defendant number 2 was inducted in the suit only because the provision mandates that the original copyright owner needs to be inducted in the suit. Without him, a copyright suit cannot sustain. There is in the plaint as well as counterclaim, no specific as such any aspiration or any claim against the original defendant number 2. The right which allegedly the defendant number 2 BC are trying to protect purportedly in the suit now is already been protected in a probate matter which is pending before this honorable court. The original defendant number 2 has made and published his last will and testament, specifically stating some rights should be granted to some persons if the probate is allowed. So in this case, if the order of vacating is not being granted, there is no loss in respect of the defendant number 2, B and C. Now, if your lordship sees the impugn order in the second page.
Yes.
Considering the aforesaid and also on perusal of the material on record, it appears to me the objection raised by the defendant number 2A should be a subject matter of full-fledged trial. Therefore, the aspect could not be restrained the defendant number 2B and 2C from entering into the suit. My humble submission is that it cannot be decided in the trial because when I have don't have any pleadings, I cannot give any evidence. My only right is to cross-examine the plaintiff, not the co-defendants. Because if there is no pleading of mine, I cannot make any co-defendant as my party adverse. and without making any party adverse, I cannot question him. So if he is supporting the plaintiff, he will not raise any question to the plaintiff in cross-section. So what is his role in the trial? And another thing, the applications were filed at delayed position. There is no explanation why the application was filed in a delayed stage, and while passing the impugn order, learned court does not at all give any reason for such delay, which the learned court deems that it should be granted or condoned, or no. Only the explanation in the order was said that the reason is hence the cause shown by the defendant number 2B and 2C in IA number 23 such and such is found sufficient. Whether this only word is found sufficient is enough for this kind of order, because there is no other reason. How it procures to be sufficient, because there is no evidentiary document was annexed with the application. I have categorically and specifically taken all those objections in my written objections. But the learned court deems to be fit to vacate the ex parte order without any cogent reason. Now, another point is, which I heard before your lordship, I have already placed the affidavit portion of the application before your lordship. Now, this is a commercial suit. After introduction of the commercial suit, there was certain amendment made to the CPC. One amendment is relating to Order 6, Rule 15A, where it's categorically stated in respect of pleadings of commercial suit, there needs to be a statement of truth. Now, this point was also heard before the learned court, but the learned court ignored this point. Now, whether the word pleadings in respect of commercial suit should only be restrained to the pleadings, or the interpretation of the word pleadings will allocate into other applications which can survive independently without any pleadings. Now, the rule of golden rule of interpretation as well as a mischief rule of interpretation. The golden rule of interpretation of statute states that any intention of the legislature should be extended by the court while dealing with the say, and the mischief rule says that if there is any gap in the statute, it should be deemed and interpreted by the honorable court, and accordingly be interpreted in jurisprudence. Now, the word pleading in the statute, whether this honorable court should restrain itself to only to the word exclusive word of the pleading, or whether in this kind of application which can survive without any pleading, the interpretation of the word pleading needs to be interpreted with the rule of golden rule and mischief rule, because there is a gap. In the statute of Commercial Court Act, there is nothing stated in regard to the applications, only to the pleadings. If there are certain applications which can survive without a pleading, it automatically absorbs the some of the characteristics of a pleading. If, for example, if today my suit got dismissed, Order 9 rule applications can survive without a pleading until the suit got.
Why are you going that far? The scope is only whether the vacating order is to be set aside or not.
No, my lord. In this, it is necessary.
And you have also not challenged these orders.
But this point has been raised, and in the impugn order.
Show me that point has been raised, how it was dealt with.
Yeah, my lord,
Show me in the impugn order that point was raised and how it was dealt with.
Considering the aforesaid and also perusal of the material on record, it appears to me the objection raised by the defendant number 2A should be a subject matter of full-fledged trial.
Yes.
My lord, this is a point of law. I don't need to be to explain.
I'm not deciding the suit now.
No, my
the
lord.
issue is whether the learned trial judge was right in vacating the order fixing the suit for ex parte hearing or not. That is the only scope.
Yes, my lord. But my contention is whether in the suit of commercial nature, can an application for vacating of expertise when there is no pleadings in my
That I follow.
survive with that kind of affidavit?
Anything more? Anything more?
No, madam.
Yes, yes, Mr. Mukherjee.
Yes, Lordship. We had the occasion to hear the superb orations by both these lawyers here. I'd only like to submit before your Lordship, there's a very small point involved in this matter, very small point. Whether a court, a civil court or a commercial court, whatever it means, a civil court. A civil court has got the jurisdiction or the authority to otherwise allow a party to contest a suit or not to contest a suit. Now, in this case, I'm appealing for the plaintiff, my lord. In this case, if the defendant is not allowed to contest the suit, the suffering will be the plaintiff. The plaintiff would be suffering. Why the plaintiff did not oppose to that situation that this particular matter should not be taken up and should be decided in favor of the defendant number 2B and 2C. 2B and 2C admittedly happens to be brother and sister. Now, in this particular matter, the annexures to the plate has not been annexed. I was just looking through the annexures. In 2014, Narayan Devnath entered into an agreement with the plaintiff to otherwise make and publish his works through the plaintiff, that is Deep Prakashan. He entered into an agreement in respect of that. In 2019, in spite of such agreement and saying to the defendant number 1, that is the petitioner herein, that you do not publish my works, still they were publishing. That is for that reason, Narayan Devnath himself wrote a letter, and also through his lawyer he wrote a letter that please do not publish my writings. This still didn't deter the defendant number 1. Finally, the plaintiff had to file a suit, and in that commercial suit, the plaintiff had to make a claim of more than 1 crore, and whatever it may be decided in the suit. But the fact remains here, the small point which is engulfed in this particular issue is whether the defendant number 2B and 2C should be allowed, so far as the plaintiff is concerned, to contest the suit. What are the aftermath of this if defendant number 2B and 2C is not allowed? Now, there are 3 points which can come up. One is they can file an application and order 21 rule 99 subsequent to the decree of the suit if it is in favor of the plaintiff. They can file an application and order 9 rule 30, we are not allowed to contest the suit. Or they can come in appeal against against
order 9 rule 13 because they were
very
order of a party.
Very difficult to come up with order 9 rule 13, but still there is every possibility they can come. What will happen then? The decision in respect of the matter, if it goes in favor of the plaintiff, that would be lost. It will take years to dispose of order. Your Lordship has been in this side of this bench. Your Lordship knows what happens when the parties are here. Now, kindly appreciate, my lord, that in this particular case, defendant number 1 comes before the court and says that the rejected application filed by 2B and 2, defendant number 2B and 2C, intending to contest the suit. Who suffers if this is not allowed? It is the plaintiff. And therefore, defendant number 1 is coming before the court and making such a huge submission to the effect that this particular matter issue is to be taken into consideration by the court. I respectfully submit would not be correct. Kindly appreciate the situation. The defendant number 2B and 2C is not allowed to contest. The matter is heard and disposed of. There is a decree against the defendant number 1 and 2, say 2A, 2B, 2C, that there is a sum of rupees X is to be paid by 2A, 2B, 2C. 2A comes in appeal, 2B and 2C will sit tight. They have also a right to come in appeal. Then what will happen when the learned judge will be hearing or the honorable court will be hearing this particular matter? First question will be asked by the division bench, why didn't you contest the suit?
No.
Now,
there is a case.
Yes, well.
Here is, it's not a case that they did not contest. Here is a case that they wanted to contest.
They still want to contest.
They should be allowed to contest.
Yes.
After that, they cannot take the point before a superior forum. Yes, why did you not contest?
Now, because the division bench will ask, why didn't you contest?
No. It's not that they
let me finish in my way. I may be wrong, absolutely. But I respectfully submit, kindly appreciate the contention made by the defendant number 1, petitioner in this case is, do not allow 2B and 2C to otherwise contest the suit. 2B and 2C contest the suit. He has also made his submissions to the effect that 2B and 2C is not entitled to put a written statement. Let us take it for granted that 2B and 2C is not entitled to put a written statement. Then they cannot contest the suit. Is it mandatory that the written statement is to be
No,
put on record?
that is Mr. Mukherjee's, junior Mr. Mukherjee's submission is that, yes, he can contest in terms of Modula India.
Yes, Modula India, yes. In terms of Modula India, he can contest.
That is his restricted right to contest.
Now, let us take it the other way around. If the plaintiff calls defendant number 2B and 2C as a witness, then what would happen? They can come and give evidence. This cannot be stopped. They can summon 2B and 2C to come and give evidence. This cannot be stopped. That the court.
No, that is for the purpose, Mr. Mukherjee, to
dispose of this.
To substantiate or prove your case.
Yes, yes.
But it's not that.
It is for
proving the case of the defendant.
No, it is to prove the case of the plaintiff. The plaintiff can call them. The plaintiff cannot otherwise act in terms of what the defendant has been doing, and the defendant, any act of the defendant or any action taken by the defendant will not otherwise partake the right of the plaintiff to prove his own case. It's the duty of the plaintiff to prove his own case. The plaintiff will try all out methods to prove their own case. Now, kindly appreciate the situation. This court is sitting in a superintending jurisdiction, not just as a revisional court. I respectfully submit within inverted comma, this court is not sitting just as a revisional court. It's sitting under the superintending jurisdiction. The trial court has allowed a party or two parties to contest a suit. One of the defendants come before the court and say, we are not going to allow the other two defendants to contest the suit. Can this be done as a matter of course within the meaning of law? Take Order 9, Rule 7, take Order 8, take anything. Can it be said that in its superintending jurisdiction, the court will say, no, these parties are not allowed to contest the suit? Your Lordship, I respectfully submit with all due respect that even the court will not be able to say you are not allowed to put in a written statement. This court cannot say that because it's a superintending jurisdiction. Whether the order was correct or not, within the purview of the provisions of Article 227 of the Constitution of India, this is to be seen by the court, not the other way around. If it is not the other way around, I respectfully submit the court will take it that it is the plaintiff who can say that the 2B and 2C should be allowed to contest. My friend rightly said that the plaintiff should sail in the same boat with defendant number 1 in respect of this issue. But unfortunately, my client doesn't agree. My client wants that the matter be heard on merits in presence of all the parties. Now, he has cited a few decisions. I'll come to those decisions. First of all, if the court permits me, I'll show these documents, but it is marked. That is a difficulty. I have marked those documents.
For what?
To show that in 2014, this agreement with defendant number 1 has gone.
Mr. Mukherjee, I'm not going that.
That is why I was keeping
only the limited scope.
Limited scope, very limited scope, my lord.
The other submission of Mr. Mukherjee, junior Mr. Mukherjee, was the original defendant number 2.
Filed a written statement.
He filed a written statement.
That has not been accepted.
That has not been accepted.
Still pending to be accepted.
Yes. Now, who is now following for acceptance of the written statement?
2B and 2C.
No. They have filed an application, not pressing that application.
Yes. After
so if that is
they have also filed an affidavit accepting the written statement. That is on record with you.
After that, he withdrew. That is the submission. Initially,
my lord, if at all no document is filed, if at all no application is filed, I say that I intend to contest the suit. Shall I be stopped from contesting the suit?
Because this order says nothing about the written statement.
Right. That is what
additional written statement.
Nothing regarding
only about allowing them to.
Even if I take the brief of 2B and 2C and say submit before the court, that sorry, they would be entitled to not to put their written statement.
Want to have a glass of water?
No, I'm having this problem for the last few days.
Want to have a glass of water?
Nonsense. My lord would pardon me. Not thanda jol. Thank you. Something ticklish is going on. It's not going. A few days back, I was unable to speak also. Your voice became so hoarse. Now, as I was submitting, my lord, the situation as it is now, if the plaintiff doesn't allow these two defendants to contest the suit, that becomes a very sore situation, very, very peculiar situation for the plaintiff. This
So Mukherjee, you take rest. Let me hear the other defendants in the
let me
meantime.
submit.
Yes. Yes.
I beg to appear on behalf of opposite party number B and C. I am the son and the daughter of.
Can come to this side.
And son of the original son and daughter. They have challenged the order for making my ex-party, getting of the ex-party order. Can a defendant oppose another defendant's application? I intend to participate in it. How are they prejudiced?
Because they are also the plaintiff with regard to the counterclaim.
If they are claiming counter, but that should have been in a separate suit. A plaintiff, I am defendant, counterclaim, accept.
That is the law.
I am a defendant in this suit. They are also defending in this.
But he has a counterclaim. In that, he is the plaintiff.
He cannot make a counterclaim against a defendant in the same suit. Cannot make a counterclaim against a co-defendant. The same. If that is the provision, then how are they prejudiced? If I am appearing before the court, how are they prejudiced? Yes, we had some personal difficulties. We could not appear before the court. I have come up. Both the defendant number 2B and 2C have come up with a vacating application along with.
What is your explanation? Is it a sufficient explanation for vacating the ex parte order?
Contest the suit.
At the mere asking, can an order of vacating ex parte hearing be vacated?
The personal difficulties on the part of the defendant number 2B and 2C.
What are the personal difficulties? What have you specified here?
Once the division of mind of the defendant number B and 2C was very bad, which is very much unknown to the other defendants or the plaintiffs. Now, the application which I had filed for vacating of the ex parte order and before the court below, the court has taken the stance that this defendant should be allowed to contest the suit. That application is in between the court and the defendant. It is a prerogative of the court and the defendant interested, and the court has allowed the defendant to participate in the suit. Now, my respectful submission before this honorable court is, how is the defendant number 1 prejudiced by my appearance before the commercial? They are not. Mere just raising few points won't suffice. We have given counterclaim against me, which they cannot.
Why? This judgment, you have considered this. 2006, 12 SCC.
And she go.
Judgment is actually saying expect a very restricted situation. Four defendants it would be a defendant. This four bylaws are not decided the law. This court decided issue application is filed by the defendant and that has been allowed. This part Obviously, what will happen in the court? Next question, like I said, that if the court has allowed you, has there been any jurisdictional error? Has there been any lack of rights exercised by the court? Has the court gone beyond the rights which the court is entitled to respect of this? That is not something I have to support, because I see that these two defendants come before the court and make their solution, whatever it may be. Maybe against me, that I will find, but they should come before the court. That is the reason why I respect the subject is happening. It's absolutely perfect, and it should not be otherwise. It's that at all. It should be that.
And the other decisions you want to make in is
2019 Supreme Court. This is already included. Already included as no application in respect of this. And saying I'm not concerned about this. Even if they are not allowed to file a statement, it's all probability they won't be allowed. If they are not allowed to file a
according to you, that stage has not yet reached.
that could be all.
Yes. Anything more?
Only regarding the jurisdictional error which my learned senior friend has argued, not only on that score, if this is the proposition of law that even the court has exercise its discretion, whether judiciously or not judiciously, under Article 227, your lordship do not have the jurisdiction to correct that error. If this is the position of law, then any delay, anything under Order 8 Rule 1, Order 9 Rule 7, Order 9 Rule 9 cannot even amenable under Article 227. If this is the law, my learned senior friend wants to let down by your lordship. But then, it is something, while the court has exercising its discretion, it's something which is beyond, can be corrected by the revision of court.
What the learned Yes, call the next matter. Document. Yes. Mr. Bose was arguing. Yes, Mr. Moinak Bose was arguing. Oh, Mr. Arindam Banerjee. Oh, yes, Mr. Bose has concluded. No, Mr. Jishnu Chaudhary. Where is Mr. Banerjee?
So the arbitration fixed at 445. That's the whole division. Well, can we get a bit of an upgradation in terms of time tomorrow?
Upgradation difficult.
And instead of 4 p.m., if it can be 3 p.m.
Mr. Banerjee, the motions are to be given priority. So after conclusion, so it is taking 3:34 to reach these matters. Because first time motion, this is a hotly contested matter.
Yes.
So it will take time. Hotly contested matters, I'm trying to keep it 3:34. So mostly I've concluded that motions at 3:30 I could reach. Only 2 matters are left of motions.
Can I get a promotion to 3:30 tomorrow?
Immediately after tomorrow is combined list matters.
Tomorrow combined list. Day after tomorrow, my lords are perhaps WhatsApp suggests that my lords will be giving me a farewell to Justice Bakchi. Day after tomorrow, and Thursday, the Bar Association from 2 p.m. will be giving farewell to Justice Bakchi. So that seals the week.
So you cannot have your chance in this week.
Perhaps. So let things remain there. Only one prayer, my lord. I am not there on Monday. Monday, my lord, I'll be coming back during afternoon. If you kindly
Juniors will be there.
my lord, kindly.
Your juniors will be there. Ask them to.
Yes.
Ask them
My
to
lord, only
remain.
for a day, my lord, kindly examine it and do not, my lord, take it out of the 4 p.m. list.
Remember that it's going for an adjournment or not.
No, we'll not oppose. Remember.
Kindly do not delete it from 4 p.m. my lord on Monday. Let it remain.
Yes. It has not yet been degraded. So let
My lord,
us
item
hope that it
48,
will
my
not
lord,
be degraded.
item 48, my lord, kindly.
48.
Next one, fixed at 4, my lord. Kindly keep it at 3:30
5.
any day.
5.
No, my lord. My lord, any day 3:30, my lord.
Motions, let me see
Lords.
after this.
Great.